Now that is the court says I'll exclude COVID period, but that can't be done because if limitations started, then my lord, in my humble submission, at least what Supreme Court now says is, if the period of limitation comes to an end within the COVID period, then there is an extension of 3 months beyond the COVID period. But if the limitation expires after the COVID period, then there is no exclusion period. Your lordship must have seen in DDA, the 3-judge bench is very clear, and our Karnataka High Court has followed that order, saying
Suomoto 3 of 2020.
yes. Now Suomoto 3 has been interpreted subsequently in Delhi Development Authority. May I just pass it on to your lordship?
But that may not be necessary. Sorry to cut
Take
you
care.
short, because Lord, I have also sought for possession. They dispossessed me, my lord, unlawfully. So therefore, possession is sought. Please see the prayer. Possession means
When
12
did
years.
they dispossess you?
Lord, they dispossessed me. I have said it in the
Yes,
my lord,
that's
23 to 2021. They have dispossessed me.
23 2.
2021.
What stopped you from immediately for seeking amendment?
Lord, they were not in the scene, my lord. 23 to 2021.
That impleading application 19/7 ಹಾಕಿದ್ರಾ ಇಲ್ವಾ?
Impleading application, my lord, is filed
19/7/21.
21. Yes, my lord. Earlier to that, my lord, they had dispossessed
Even
me.
worse.
It's all right, sir. 19/7/21. Earlier to that and worse off. Now 19/3/2021, 23/2021 they dispossessed you.
Yes, my lord.
You knew that they had something with them.
True, my lord.
Immediate ಆಗಿ ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ?
My lord, there was stay of further proceedings because, my lord,
Where?
here before this court.
Which petition? Which petition, sir? ಇದು 2/24. Earlier ಯಾವ್ದಾರು ಹಾಕಿದ್ರಾ?
Earlier, my lord, there was one matter.
Which matter?
After impleading, we've completed our evidence as well as defendants. After that, Lord, this application comes to
No,
be
my
filed.
lord, I'll give that particular. Lord, it is a sale deed that has happened during the pendency of the suit. Lord, question of limitation will not arise. That is the first aspect. Second aspect, my lord, is they dispossess me. My lord, for me to collect particulars, my lord, they are not a party. When I was collecting particulars, my lord, they would come and file an application. That application, my lord, finally is allowed. My lord, and amendment is carried out on 27/7/2023. They come on record. Immediately, my lord, I filed the application, my lord, on 25/7/2024.
Which is the earlier one more petition. If stay is granted here of further proceedings, then we'll see.
But my application was filed in July of
I don't
2020.
know what petition is saying.
July 21.
I'll just check, my lord, because I was told that there was a stay. But I don't have the particulars. My lord, independent of that.
No, independent of that, kashta. We'll see. Day after tomorrow. Day after tomorrow in preliminary hearing, produce that order or petition, whatever it is. Yes, next. Heard the learned senior counsel Dhyan Chinnappa appearing for the petitioner and Abhinav so representing the respondent. List day after tomorrow. Preliminary. AG has come. AG,
I'm sorry. Can it be on Tuesday? My lord? I'm so sorry. Can it be on Tuesday?
no, Wednesday or
Wednesday.
Friday? Wednesday, yes. Wednesday, list on Wednesday, I think 6th. Yes.
Kindly pardon my absence, not yesterday.
ಪರವಾಗಿಲ್ಲ. ಅದೆಲ್ಲ ಏಜಿ ಅವ್ರೇನು ಬೇಜಾರು ಮಾಡ್ಕೊಳ್ಳೋ. ಈಗೇನು ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ಳಿ.
We, in fact, not both of us, including not the officials, not in the department, made but efforts to not see that quietus is given to this. Ultimately, officers also, not senior officers also say,
I will give it now.
whether it is 89 packages or 2 package or 4 package or 33, whatever. Ultimately, my lord, we will have to work and kasa tegeyodu onde ulidirodu. Number of packages.
Ultimately, my lord, only these people are there. Whether in their 89 or 30 condensed form or a larger form is the only thing. Nobody else can come in this garbage, my lord. It is only.
But review.
I'll just
And
bring
one
to
other,
lordship
just
notice.
before 2 minutes, my lord, just to explain in this form and review petition, what your lordships have done, we have placed on record that we are implementing it. Instead of 4 months, we have sought for 6 months time, my lord, and we given the time schedule also. What
Eಲ್ಲಿದೆ?
court of or other side copy could be there.
ಅಷ್ಟೇ. We'll close it, Prasanna.
We'll note.
Lordship, can you just-
This garbage problem will not get
Page
solved.
5, my lord,
Yes.
just page 5, my lord.
Hmm.
Is the time schedule to complete your lordship's direction, my lord. And insofar as your lordship have already permitted us to withdraw that 89 packages, that is which is the 33 packages, my lord. That's the only thing, my lord.
We will direct them to continue this
Can I
timeline.
just not see this and come back?
ಅರೆ,
Maybe-
ಏನ್-
ಅಲ್ಲ,
Yeah,
ಏನ್
I'll
ಬರೀ
come.
timeline
Your
ಕೊಟ್ಟಿರೋದು
ಅದು
ಕೋರ್ಟಿಗೆ.
ಏನೋ ಗೊತ್ತಿಲ್ಲ ಇದು. I'll just go through this and come back. Maybe
Come back.
I'll come back today. Just half an hour.
5 o'clock.
And one other thing, my lord, this is to
Yes.
comply with your lordship's order. That has nothing to do with.
And review,
I'll-
I thought clarification or recall ಹಾಕಿದ್ರು, review.
I didn't point out that to your lordship in the beginning. Reason is I wanted to satisfy your lordship that we are not violating your lordship's order, my lord. My only.
Anyway, we'll close
Yes,
this
5
review.
o'clock.
Yes, dismiss.
I ನೋಡ್ಬಿಡ್ತೀನಿ ಏನು.
ಏನ್ go through ಇಲ್ಲ ಬಿಡಿ.
I'll just not have it.
Go through ಏನಾದ್ರು change ಆಗಲ್ಲ. Yes. ಅಷ್ಟು closed,
ಅಲ್ಲ,
dismissed.
ರಾಷ್ಟ್ರ kindly ಪಾಸ್ವರ್ಡ್ ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಅಂತ let me also not have it. Satisfy myself not before.
ಆಯ್ತು.
We'll come back in 5 minutes, my lord.
Fine.
Not that he does not know what is the only.
No, I
ಮುಂಚೆನೆ
don't-
ಗೊತ್ತಿರುತ್ತೆ.
I do not- really do not.
Well
Can you come back by
connected.
3:30 minutes if your lordship permits?
All right,
Please,
half an hour.
please.
Please.
Password.
Appearing for the respondent, my lords. My lords, another 3 matters have received the wakalat yesterday, my lords. I shall file that, my lords. The matter may be.
Enter ಮಾಡಿದ್ಯಾ?
ಇದೆ.
To maintain status quo ಅಂತ ಇದೆ.
They've challenged the order
ಇಲ್ಲ,
of
ಇವಾಗ
the
there
local
is some
adalat, my lords.
interference.
What interference?
They're attempting to come into the property and do something locally. That's the reason.
No, my lords.
Attempt
happened?
to. Ah,
My lords, they've challenged the order of the
Last
local
time my
adalat,
learned
my
friend
lords.
said that they will appear for all the respondents, all the matters, same respondents.
ಈಗ ವಕಾಲತ್ ಬಂದಿದ್ಯಾ?
ಬಂದಿದೆ.
ಎಲ್ಲಾರ್ದು ಆಗಿದ್ಯಲ್ಲ? ನಿಮ್ಮ ಹೆಸರು ತೋರ್ಸಾಗಿದೆ.
Other wakalat not filed ಅಂತ.
ಪರವಾಗಿಲ್ಲ, ಆಯ್ತು.
My lords, that's what, my lords, they have challenged the order of the local on the ground of fraud, my lords. My lords, the writ is not maintainable. The remedy
Why?
is before the civil court, my lords. If they're
23(3)A.
alleging fraud- Because they've alleged fraud, my
No,
lords.
23(3)A. ಲೋಕ ಅದಾಲತ್ ಆದ್ರೆ ಇಲ್ಲೇ.
ಹೌದು ಅದು.
Lok Adalat ಇದೆ ಇಲ್ಲ 22E of the Act says there is no suit. I have
If
to
it
come
is
here.
in the court
Ah.
compromise, 23(3)A.
Correct.
ಅಲ್ಲ ಅದನ್ನೇ.
ಲೋಕ ಅದಾಲತ್ ಇಲ್ಲೇ.
Lok Adalat ಇಲ್ಲೇ ಬರುತ್ತೆ.
My lords, there are
Now,
2
what has
judgments, my
happened, my
lords.
lords, the coordinate bench, this honorable court has also seen fraud, it can't be everything. This honorable court can't see what has happened here. What has happened?
ಡಾಕ್ಯುಮೆಂಟರಿ ಫ್ರಾಡ್ ಆಲ್ಸೋ ಸಾಕು,
ಹೌದು.
ಬೇರೆ ಏನ್ ಬೇಕಾಗಿಲ್ಲ. ಎವಿಡೆನ್ಸ್ ಬೇಡದೇ ಇರೋ
face of
ಫ್ರಾಡ್
it.
ಇದೆ.
On
ಎಲ್ಲಾ
the face
ಫ್ರಾಡ್
of
ಅಲ್ಲೂ
it.
ಎವಿಡೆನ್ಸ್ ಬೇಕಾಗಿಲ್ಲ. If it is palpable and demonstrable here,
On the face of it, it is there.
It was a suit for partition. They have distributed among themselves. They have entered
18
into a
years
compromise,
before-
my lords.
Says 12 or 14 years before the partition suit, father himself has got the land converted, created sites and sold the sites to individuals, and we are all purchasers. Then this
ಸೂಟ್ ಹಾಕಿದ್ಯಾರು?
suit siblings ಹಾಕೊಂಡ್ಬಿಡ್ತಾರೆ
After the death of the father?
after the death of the father.
ಹಾ.
My lords may kindly see. The respondents before my lords are all the children of one Munshamaya. He purchases.
ಮುನ್ಷಾಮಯ್ಯ sells
He
the
purchases a
suit scheduled property.
In 68, he purchases it.
ಹಾ.
In 1992, annexure C, he gets it converted from agricultural use
non-agricultural.
to
Residential purpose.
residential use.
Hmm.
He forms a layout
Hmm.
and he sells sites. All in the
Last of the site sold ಯಾವಾಗ?
1997 ಅಲ್ಲೆಲ್ಲ ಮಾರ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
1997. ನೀವೆಲ್ಲ ಮನೆ ಕಟ್ಕೊಂಡಿದ್ದೀರಾ ಅಲ್ಲಿ?
Some are vacant.
All right, ಸರಿ.
Khata has been issued by BBMP.
Suit instituted when?
Suit is instituted in
First before the
2019.
death ಯಾವಾಗ?
2019. Death, I'm not sure when he is that.
But he is dead, you are sure?
They say they
All
late
right,
ಅಂತಾನೆ
yes.
ಹೇಳ್ತಾರೆ. 2019 ನಲ್ಲಿ sisters file against the brothers. They say that this is father's property, it's ancestral. Brothers say yes. They go before the Lok Adalat and say out of this 1 acre 14 they continue to contend that it is agricultural land. 2 acres is allowed, 2 guntas each is allotted to the sisters, and they enter into a compromise before the Lok Adalat. By which time I have purchased, I have
ಅದಾಯ್ತು, ನಿಮ್ ಲಾಂಗ್ ಬ್ಯಾಕ್ 97 ಮುಂಚೆನೆ ಆಗೋಗಿದೆ ಎಲ್ಲ.
ಖಾತಾ ಆಗಿದೆ, taxes ಕಟ್ಟಿದ್ದೀನಿ. And they don't reveal before the civil court or before the Lok Adalat that father has alienated the property more than 12 years ago.
ನಿಮ್ಗೆ ಗೊತ್ತಿರ್ಲಿಲ್ವಾ ಅದು?
My lords, that is not what they're saying, my lords. My lords, I'm a little handicapped without the file today, my lords, because
You are here without a file.
my lords, somebody.
Take some file and stand.
No, that's
Yes.
not.
And the extra copy.
Extra copy ಕೊಡಿ.
ಕೊಡಿ.
Yes.
It may be taken up on Thursday or Friday, my lords.
For
That only.
my reference, I will just narrate.
Please, my lords, please. My lords may
The-
kindly
1
see
minute.
one of the 4 writ petitions, 1, 2,
ಯಾವ
8,
ನೀವು
3.
ಹೇಳಿದ ಫ್ಯಾಕ್ಟ್ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ.
Please.
Heard the learned counsel Kamala Charan appearing for the petitioner and Siri representing the respondent. The learned counsel Siri R submits that she would be entering appearance to all the respondents in all the cases. Registry to print the name of so and so is appearing for the respondent. The learned counsel for the petitioner submits that the suit schedule property was initially purchased by one Monishamaya in the year 1968.
24/12/1968.
24/12/1968. Munishamaya gets the land converted from residential, from agriculture to residential purposes in the year 1992.
22/9/92.
22/9/1992. After the conversion, it transpires that Munishamaya formed layouts, formed sites, formed a layout comprising of sites
18
and
sites.
sold, how many sites?
18 sites he created.
18 sites and sold those sites.
Petitioners are here.
One
for
nimisha.
13
Sold
sites.
those sites, and the last of the sale happens in the year 1997. The petitioners have purchased those sites. Few of the petition, ನೀವೆಲ್ಲರೂ ಇದ್ದೀರಾ?
Similar.
The petitioners have purchased the sites and are in possession of the
13
property.
sites. my lords.
13 sites are, petitioners have purchased 13 sites and are in possession thereof since the said date. And all statutory requirement for such possession is also in possession of the petitioners. The respondent, in the year 2019, after the death of Munishamaya, the respondents,
1 and 2.
Respondents 1 and 2 file a suit for partition.
84/30
The
of 2000.
suit schedule property is the same that was converted, sold and formed sites as the case would be. Immediately after filing of the suit, the family members enter into a compromise of division of the property that was already sold 20 years ago, 30 years ago rather, sold 30 years ago, close to 30 years ago, and are now compromised and are now in possession of an order or a decree in terms of the said compromise. The petitioners did not know of these facts. In the light of the knowledge of the compromise entered into of the property that had already been sold long ago, and the compromise being entered into on the score that it was still an agricultural land, have knocked at the doors of this court in the subject petition, calling in question the compromise and the decree so drawn on compromise, alleging fraud or a collusive decree amongst the members of the family of a land that was not even available for partition. In that light, the respondents, in that light, the decree so passed and all further action taken thereto shall remain stayed till the next date of hearing. When do you want, madam?
The status quo is already there. my
No
lords.
problem. I am staying it.
So
Yes.
next Monday, my lords.
Next Monday?
Please,
This
my
is
lords.
list the
compromised
matter.
before the Lok Adalat. my lords.
Lok Adalat ಹೇಳಿದ್ನ.
ಬಂದಿಲ್ಲ ಅನ್ಸುತ್ತೆ.
I will see, yes. List on 6th ಆಗ್ಬೋದಾ, 13th ಆಗ್ಬೋದಾ, 20th ಆಗ್ಬೋದಾ? ಯಾವತ್ ಬೇಕು ಹೇಳಿ.
6th, my lords.
6th. Great.
Petitioner, my lord. Either last occasion, your lordship directed the respondent counsel to produce the certain documents.
What talking?
ಅವ್ರೇನು ನಾವು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಈಗ ಯಾಕೆ ಬಂದಿದ್ದೀರಾ ಹೇಳಿ.
ನಾನು ಫಾರ್ ಬೇರ್ ಇಂಜಂಕ್ಷನ್ my lord suit. I file an application for granting of the injunction.
ಈಗ ಕೊಡ್ಲಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ.
ಅಪೀಲ್ ಹಾಕಿದ್ರ?
ಅಪೀಲು ಡಿಸ್ಮಿಸ್.
ಕನ್ಕರೆಂಟ್.
ಇಲ್ಲ.
ಅಲ್ಲೇ ಹೋಗ್ಬಿಡಿ.
ಅಲ್ಲ my lord, one submission. He is disturbing my possessory right. First of all, he claiming the bogus sale deed by name, in the name of his vendor Ekantayya. Ekantayya is a stranger. ನಾನಾಗಲಿ ಅಥವಾ ನನ್ನ ಲೀಗಲ್ ಯಾರು ಏಕಾಂತನಿಗೆ ನಮ್ಮ ಲ್ಯಾಂಡ್ ಮಾರಿಲ್ಲ.
ನೀವ್ ಯಾರು?
I am the original owner of the son.
Original owner of the
Owner,
son.
original
One
owner
of the original owners.
Original owner one ರಂಗಪ್ಪ ಮರಡ. Original one ರಂಗಪ್ಪ. ರಂಗಪ್ಪನ ಮಗ ನಾನು.
ಮತ್ತೆ ರಂಗಪ್ಪನ ಮಗ.
Because ತಡಿ ಹೇಳ್ತೀನಿ. That too, the property extent in the year of 1906, my lord. 1906 ಇಸ್ವಿಯಲ್ಲಿ 30 ಎಕರೆ ಕೊಂಡ್ಕೊಂಡಿರೋದು.
Where Rangappa?
Rangappa.
Oh, Rangappa.
Absolute.
Huh? How are you coming in?
ಈ ಕ್ರಿಯೇಟಿಂಗ್ ಮಾಡಕ್ ಒಂದ್ ಸಬ್ಮಿಷನ್ ಅವ್ರು ಹೇಳ್ತೀನಿ
ಅರೆ ಈಗ ತಾನೆ ನೀವೇ ಹೇಳ್ತೀನಿ ಹೇಳಿ.
ಅಲ್ಲಿ ಒಂದು ಸೇಲ್ ಡೀಡ್ ನನ್ಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಲೆ ಒಂದು ಸೇಲ್ ಡೀಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಒಂದ್ ಸೆಕೆಂಡ್ ಅದರಲ್ಲಿ ಯಾವ ದಿನ ಕೊಂಡುಕೊಂಡೆ ಎಂಬುದು ಏನೂ ಬರ್ದಿಲ್ಲ. ನಾನು ಈ ದಿನ ನನ್ನ ಬಾಬ್ತು ನನ್ನ ಖಾತೆ ಸ್ವಾಧೀನ ಅನುಭವದಲ್ಲಿರುವ ಅಂದ್ರೆ ಈಸ್ ವೆಂಡರ್ ಕೆಳಕಂಡ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ನಮೂದಿಸಿರುವ ಸ್ಥಿರ ಸ್ವತ್ತನ್ನು ನಾನು ಕ್ರಯಕ್ಕೆ ಪಡೆದಿದ್ದು ನನ್ನ ಹೆಸರಿಗೆ ವರ್ಗಾಯಿಸಿಕೊಂಡೆ ಅಷ್ಟೇ.
1906 ಇಂದ ನೀವೇ ಇದ್ದೀರಾ?
ನಾವೇ ಇರೋದು. ಮತ್ತೆ ಇನ್ನೇನ್ ನಾವು ಯಾಕಂದ್ರೆ ಸಟನ್ ಪೋರ್ಷನ್
ಸ್ಟಿಲ್ ಅಲೈವ್.
ಎಲ್ಲಿ certain portion, your lordship aware that certain portion of the land, our land is acquired by the National Highway authorities. ಅದನ್ನ ಅಕ್ವೈರ್ ಮಾಡಿಕೊಂಡಿದ ಮೇಲೆ ನಮಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನ್ಯಾಷನಲ್ ಹೈವೇ ಅಥಾರಿಟೀಸ್ ಅಂಡ್ ಸಟನ್ ಇದು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಮಿಡ್ಲ್ ಅಲ್ಲಿ ಅವ್ರು ಬಂದು ಇದನ್ನ ಕ್ರಿಯೇಟ್ ಮಾಡಿಕೊಂಡು ನಮ್ಮ ಪೊಸಿಷನ್ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಾರೆ. ದಟ್ ಈಸ್ ದಿ ಕೇಸ್ ಮೇಲೆ. ಆಮೇಲೆ
ಹೇಳಿ ಅದ್ಯಾಕೆ
ಶೆಡ್ಯೂಲ್ ಅವ್ರು ಹಾಕಿರೋ ಶೆಡ್ಯೂಲ್ಗೂ ನಾವು ಕ್ಲೈಮ್ ಮಾಡ್ತಕ್ಕಂಥ ಶೆಡ್ಯೂಲ್ಗೂ ಟ್ಯಾಲಿನೇ ಇಲ್ಲ ಮಲಾಡ್.
ಇಂಜೆಕ್ಷನ್ಸ್ ಏನಾಗ್ತಾ ಇದೆ ಕೊಡಿ ಅವ್ರ ಕಾಪಿ
ಕೊಟ್ಟಿದ್ದಾರೆ
ಇವತ್ತು ಕೊಟ್ರ
ಈಗ ಅದು
ಈಗ
ಕೊಟ್ಟಿದ್ದೇನೆ.
ಆಯ್ತು ಬುಧವಾರ ತಗೊಳ್ಳ
ಬುಧವಾರ ಆಯ್ತು ಮಾಡಿ ಕೊಡುವ.
ಆಯ್ತು ಅದು ರಿಜಿಸ್ಟ್ರಿಲ್ ಫೈಲ್ ಮಾಡಿ. Learned counsel for the respondent seeks to file a statement of objections. The same be filed before the registry list on 6th. CRP.
Two partition suits are pending for consideration. Against the.
This matter.
Please, Section 10 and Art 2 Rule 2, my lord. My lord, I am permitted to submit in chronological order, please.
What is sir?
No, my lord, I will.
That is better.
Please.
ಇಲ್ಲ ಅಂದ್ರೆ ಫೋಟೋ ನೋಡ್ಕೊಂಡು ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Please.
Yes. Counsel for the petitioner seeks leave.
May I submit?
File synopsis file ಮಾಡಿ.
Please.
Seeks leave to file a short synopsis of list of dates and events. Take it on 13th.
Please.
List on 13th. Enter ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ.
13th. Yes.
I appear for the petitioner, ma'am. This is a case where I have challenged rejection of my application filed under 1 Rule 10 to delete myself from the proceedings. I was granted an interim order, my lord, directing no further proceedings before the trial court.
No.
Main ground was that there was no privity of contract.
Interim order. What was the interim order?
No further to stay further proceedings before the commercial court. On the last hearing, they sought time to file statement of objections
ಹಾಕಿದ್ದೀರಾ?
until today.
I am for the respondent number 1. I will
Sole respondent
file
at this moment.
detailed objection here. Provided 7 days time is given.
Oh, yeah, definitely. Sir. Yes. List the matter on 13th at the request of the counsel appearing for the respondent who seeks time to file statement of objections. Interim order subsisting would continue to the next date of hearing.
Great.
Yes, next.
Section 12 of the Commercial Court Act. Suit for ejectment filed by the plaintiff. The non-compliance of the provision under 12A.
My lord, I filed the synopsis as well as a Dhanbad oil judgment, my lord.
Yes, sir.
There is an interim relief that has been sought for.
Where is your affidavit seeking interim relief?
My lord, I number 1, my lord, at page 25.
Page?
25, my lord.
What's the urgency projected?
My lord, I'm the owner, he's the tenant. The
Correct.
apprehension made out, my lord, is that he will sublet the property.
Application for exemption filed under.
No, where is the application?
25 page.
Page 25, my lord.
26 is the affidavit.
What is the urgency projected here?
Nothing has been stated. Only stated in the para page 29, para 17, we submit that we have undergone exorbitant financial losses due to the continual
Legal
illegal
occupation.
occupation, scheduled property by the defendant even after expiry of term.
Go to 12A, sir. Finish 12A and come.
My lord, there's 2 points which I would like to point out.
Ah.
My lord, I have placed Dunbar judgment before
No
the
problem.
court. My lord could kindly take para 46 of that judgment.
Yes, sir.
My lord, the court there, my lord, has explained that what is the extreme urgency which the court needs to look into.
Correct. What is
My
the
lord-
extreme urgency?
My lord kindly takes para 46 of the
I am
judgment.
there,
my
sir.
lord.
Yes.
At page 40.
I am
page-
there, sir.
Page
In
31, my lord.
in partial automation.
No, my lord, at page 31, my lord, of the judgment which I filed.
Which?
I filed a synopsis.
Dhanbadalva.
Yamini Manohar case. That is a
Yamini
different
Manohar.
case.
That is what is explained,
Which
my lord, by
judgment,
the-
sir?
my lord, along with the synopsis. I
Dhanbad
have filed.
fuels, right?
Dhanbad fuels.
Paragraph,
Paragraph 42, my lord.
tell me.
How the expression urgent interim relief is to be construed.
Hmm.
My lord, I would request you to straight away come to para 44, my lord, where it concludes. As it becomes clear that from a perusal of the aforesaid decision that the test under 12A is not whether the prayer for the urgent interim relief actually comes to be allowed or not, but whether on examination of the nature of the subject matter of the suit and the cause of action, the prayer for urgent relief by the plaintiff could be said to be contemptible by the matter is seen from the standpoint of the plaintiff. Further, what is also to be kept in mind by the court is that the urgent interim relief must not be merely an unfounded excuse by the plaintiff to bypass the mandatory requirement of 12A of the 2015. My lord, IA1 has been allowed. They have not questioned that IA.
What, IA1 for what?
IA1, the IA where, my lord, I have asked for the injunction to say that they are subletting the property. That IA has been allowed. It is not questioned. I have now, my lord, also filed a contempt application on that because they have now tried to sublet someone into the property. A 39(2A) also is filed and pending.
Yes.
These are, my lord, the facts and circumstances from the plaintiff's standpoint of view, which, my lord, would have to be
If the
considered.
plaint itself could not have been entertained without 12A, except save in circumstances of
My lord, the saving circumstances, my
urgency.
lord, is explained, my lord, in the plaint also, my lord. In the plaint, my lord, if my lord takes.
No, the plaint is not required, but urgent relief should be pleaded in the affidavit why you want an interim order or entertainment of the petition dehorse
It
12A.
is because, my lord, they are subletting and they have actually now sublet the property. My lord, if I could just pass on, my lord.
Where have
the-
you so said in the affidavit?
Lord, let me.
Lord, kindly see.
To frustrate the claim you have sublet the property
No, it is
also?
absolutely,
Lord,
it is under construction project that will not arise at all.
My lord, he is
Now RERA is
paid
not
any
reviewed
rents
at
to
all.
me. He is squatting on the property
Under
since 2
construction
years.
project.
Please,
From 2 years, my lord, the rents are not paid. There is a sale deed in my favor.
That is
in
why
the-
you are before the court anyway. It's
Statement, my lord,
it's
they
an
kept-
appropriate case for 12A.
My lord, they file a written statement saying that the sale deed is fraud. There is no counterclaim set up in the written statement to at least strike down that sale deed to say that it is illegal and void.
that's a separate
My lord,
procedure.
We are-
my lord, I have filed 2
Now
IAs, my
he
lord.
is on 12A,
Please.
non-compliance with
My
12A.
lord, if
Also, your
And
lordship
it is a suit directly instituted before the commercial court.
please,
It is not a suit that is made over to the commercial court.
my lord, I have also filed IA number 2, my lord, where the requirements of PIM is dispensed with. I have filed an IA
It's
number.
already dispensed.
Yes, my lord, I have filed IA number 2, which to,
That's
of
not
course,
challenged?
that is also challenged. It is
that is
IA number 2
questionable.
and 3
Your
are both
lordship kindly
challenged
see,
here.
12A filed for exemption from pre-institution of the mediation.
I know it's
That
that.
was not considered at all. Without considering, passed an order on IA1 for under order 39 rule 1 and 2.
My lord, that is also passed. My lord, the tenant, my lord, is squatting on the property, not paid rent for more than 1 year.
Ah.
And when I initiate this
Pay
suit, my lord,
ಮಾಡ್ತೀರಾ?
he comes up with this defense.
Huh?
Actually, what has happened, this is not a tenant and landlord relationship. This is only a purely financial transaction. He filed various Chapons cases against me in Bangalore and Hyderabad. In addition, and
You-
also I filed a criminal complaint against
It's all
the
right. You pinched
Sir,
him
I'm
in
not
the,
stayed
no,
now
no.
already.
You appear to have pinched him in the wrong nerve.
My lord,
Yes.
my lord, but the suit, my lord, is now going on, my lord, for quite some time. It's
What
also,
to do,
I've
sir?
finished the evidence as well. My lord, the PIM has been dispensed with by the court after considering the urgent
What is the
circumstances.
stage of the proceeding?
My lord,
No,
it's
it's
for the
cross of
further
PW
cross of PW1. I've
When
completed
did
my
you,
chief.
where is the application for exemption in 12A? When did you file it?
I filed it along with the suit, my
along with
lord.
the plaint.
Along with the plain, it was filed, my lord, at page number
Then when it is rejected?
8-1.
8/1/2025. What to
25.
do?
The-
Lordship, kindly
Fault
see
of the
the
court.
order sheet. It doesn't mention of the IA2, 12A. Not considered.
An order is
Summons
passed.
has been
eventually. It's a
issued in
common
respect of
order that is
IA1.
passed. If my lord sees the impugned order, my lord, the court has given reasons to say why, by examining partial automotion. It says, my lord, for these reasons, if I could take my lord to the impugned portion alone, my lord.
In this case, difficult, sir.
My lord, could you please look at page 96? for one
Nothing
moment?
is found in the
This
affidavit.
page 96 for one moment, my lord. The
Yes.
reasoning that is given by the, in the impugned order. In Patil automation, that's from the middle of the page. In Patil automation, the suit was for recovery of money and there was no urgent interim relief was sought for. In the present case, the plaintiff claiming to be the absolute owner of the suit property have allegedly entered into the defendant with a leave and license agreement. Plaintiffs have sought for the recovery of the suit property by evicting the
No, the
defendants.
mandate of 12A does not depend on the nature of the claim, whether it is recovery of money or eviction or whatever. 12A
The
is to
court
be
is only
complied
differentiating between.
if you are before the commercial
But
court.
the only test that would have to be applied based on Dhanbad Oils, my lord, is if it is looked at from the plaintiff's standpoint of view, which now I am kind of vindicated because he's sublet the property. I have filed, my lord, a 39(2)A application for disobedience of the injunction that's been granted by the court. If that is not,
Where is it, the sublet document you have?
my lord, I have filed the 39(2)A application.
No
my lord.
document you have of subleasing?
My lord, I have a photograph, my lord, where they have
Not
put
produced
the
any-
photo of some other business entity that is occupying the property. That is what I filed to show, because I don't have the, ma'am.
Kodil.
And they have not challenged that IA number 1. I filed IA number 4 asking for permission to put up a board outside the property, which they have challenged by filing a commercial appeal, by saying that the board should not be put. So my lord sees the last page alone, my lord, there is this photograph, my lord, which says capital launching premium 2 and 3 bed residence, and then they have that board over there, which is what was the apprehension I made out, and which is why the injunction was granted in the first place. Now for non-compliance with that order, I filed the disobedience 39(2)A as well.
The interim order is here.
ಇಲ್ಲ sir.
ಅಲ್ಲೇ ಹೋಗ್ಬಿಡಿ. Cross examination ಎಲ್ಲ ಮುಗಿಸ್ಕೊಂಡ್ಬಿಡಿ.
ಅಲ್ಲ, it is purely based on the, no, I have not sublet any of this portion of the property to third party. This is afterthought. Your lordship kindly see,
File an affidavit.
I'll file up with it.
My lord, IA number 4 is filed. I filed IA number 4 saying I want to paint the case number outside the property because I have an apprehension that he had subletted. They opposed that IA was allowed. I put up a board.
Objections are filed to that IA.
Yes, objection.
Where
I do
is
not have it with me right now. I'll place it, my lord.
Place that
Other mail,
objection.
no,
What
I
is the
filed a
objection
contempt.
they have filed?
That too, I have filed a contempt, my lord, because they erased the paint which I had put over there, and they have now challenged that by filing a commercial appeal before the division bench.
Friday?
Yes, please.
Friday and
Place the
preliminary
contempt
hearing.
document.
Yes. Next. Tax. ಅರ್ಜನಾಗಿಲ್ಲ ಮೇಡಮ್. ಇಂಟರ್ ಆರ್ಡರ್ ಇದೆಯಾ? ಇದ್ರೆ 28th. 78 to 28, same 28. Also adjourned.
For the respondent, for the petitioner, Mills may request the matter to be taken up on Monday, Mills. It's coming up in Supreme Court.
Supreme Court ಅಲ್ಲಿ ಏನಾಗಿದೆ?
First step website, advance list is out. It's posted on first Mills, day after tomorrow.
Monday.
Alla, see,
Just a request, Mills.
one nimisha. See, Supreme Court, they moved the application, they prayed for time. They prayed
The
for
list
the Supreme
ಇದೆಯಲ್ಲ,
Court.
on Monday.
Supreme Court did not grant this stay.
ಕೊಡಿಲ್.
On 18/7 it was there, Mills. Notice is issued. It's on first for hearing, Mills.
18/7, they pressed for time, the court did not grant this stay.
ಈಗ 20 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಿರಲ್ಲ?
ಮಾಡಿದೀನಿ, Mills.
Withdraw
30 lakhs
ಮಾಡ್ಲಿ ಬಿಡಿ.
totally. Mills, let it be subject to the inquiry in mean profit. Mills, a connected writ petition.
Paid more than the 36 lakhs to them. Supreme Court has granted 20 lakh rupees towards mean profits 3 years back.
Court has said that, what is the
3 years back, Supreme Court has directed them to pay 20 lakh rupees towards mean profits. That was 3 years over. 3 years in the 1 rupee undilla.
ಕೊಡಿ.
Mills, I'm
From
filing-
3 years, not even 1 rupee is paid.
Mills, with kind leave, I'll file objections to the IA, Mills, for
No,
withdrawal.
no, wait, sir. 4/5/20, who went to the Supreme Court?
ಅವರೇ ಹಾಕಿದ್ದು.
ನಾವೇ ಹೋಗಿ.
ಇದರಲ್ಲಿ shall pay respondent a sum of rupees 20 lakhs within 3 weeks from today. Pay ಮಾಡಿದ್ರಾ?
ಎಕ್ಸ್ಕ್ಯೂಷನ್ ಹಾಕಿ 6 ತಿಂಗಳಲ್ಲಿ ಕೊಟ್ರು ಆಮೇಲೆ.
ಇಲ್ಲ,
ವಾರಂಟ್ ತಗೊಂಡೋಗಿ ಕೊಟ್ರು.
And I filed the memo of calculation.
ಅಲ್ಲ 3 weeks ಅಲ್ಲಿ ಕೊಡ್ಲಿಲ್ವಾ?
3 weeks ಅಲ್ಲಿ ಕೊಡ್ಲಿಲ್ಲ.
ಯಾವತ್ತು ಕೊಟ್ರು?
ಎಕ್ಸ್ಕ್ಯೂಷನ್ ಹಾಕಿದ್ವಿ. ಎಕ್ಸ್ಕ್ಯೂಷನ್ ಹಾಕಿ ತಗೊಂಡ್ವಿ. 2 ಸಲ ವಾರಂಟ್ ತಗೊಂಡೋಗಿ ಆಯ್ತು.
No warrant to continue the interim order. Supreme Court ಅಲ್ಲಿ ಕೇಳ್ಕೊಳ್ಳಿ.
Whether so far as this is concerned, I have filed the memo of calculation. On
Memo ಎಲ್ಲ before the Supreme Court. The only reason I granted stay was it was not before the,
Vacation
order code. Yes.
My card after first.
No, sir. Whatever it is before the apex court, you can urge. This court on 9/6/2025,
Fellas, in
when the matter came up for its,
case, I'll withdraw my writ petition. I'll withdraw my writ petition.
after arguing the matter at length, learned counsel for the petitioner would seek to withdraw the petition in the light of the matter being listed before the apex court on the 1st of August 2025. The petition is disposed as withdrawn.
Great.
The other petition is
81.2, 81.1.
Allah, the amount may be altered to be.
ಯಾವ್ದ್ರದ್ದು?
Petition
Al Supreme Court, yes.
Allah,
Withdrawal ಅಲ್ಲಿ ಬಂತು, yes.
I filed the application withdraw.
ಅಲ್ಲಿ ಅಪೆಕ್ಸ್ ಪೋರ್ಟಲ್ ಕೇಳ್ಬಿಡಿ.
Calculation ನಾನು ಹಾಕಿದ್ದೀನಿ 24.
ಈಗ ನಿಮ್ದು ಇದೇನು?
The amount is.
81.1 ಏನು?
That is.
May I make one submission?
My lord,
May I make one submission? May I make one submission? Let the amount be transferred to the trial court in FDP 82.
That I will do.
Please kindly do it.
With the disposal of the petition as withdrawn, the amount in deposit, comma, if any, before the registry of this court shall be transmitted forthwith to the concerned court in FDP
82
82 of
20,
FDP 82 of 2020.
pending on quota number 2, CCS number 2.
ನೋಡ್ತಾರೆ ಬಿಡಿ. So, yes.
And so what this is.
And the court may pass appropriate orders for dispersal.
ಅದಾದ್ಮೇಲೆ ಅಲ್ಲಿ ಕೇಳಿ. Yes.
Lord, in this case, I have actually made an application on order 18/17. To recall DW1 for the purpose of producing evidence so far as mean profit is payable. That is came to be dismissed.
That is what is challenged here.
Yes. One opportunity for me to say, because I have received the amount and I have to give account for them and I have made the calculations also.
ಅಲೋ ಮಾಡಕ್ಕೆ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ವಂತೆ, ವೇಟ್.
ಅದೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. I have filed an application for appointment to commissioner. A commissioner can also be appointed for the purpose of ascertaining his mean profits.
ಅದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ತೀರ್ಮಾನ ಮಾಡ್ಲಿ.
That may be.
ಇದೊಂದು ಒಂದು ಆಪರ್ಚುನಿಟಿ we will grant him.
Yes.
Yes. The petitioner.
The court may also appoint a commissioner in view of this.
I will direct the court to do so.
Yes.
The petitioner is before this court calling in question an order dated 2/9/2024 rejecting an application filed by the petitioner in order 18 rule 17 of the CPC seeking recall of Yarna DW1 for further cross examination. For further examination. The petitioners are the defendants.
Respondents.
FDP. Petitioners are the respondents. The proceeding is pending in FDP 82 of 2020. In the proceedings, the petitioner files an application, petitioners 1 to 3, represented by the SPA holder, files application in IA 17 under order 18 rule 17 seeking recall of DW1/RW1 for further cross examination. The concerned court by the impugned order has rejected the same. Further examination, sorry. Further examination, the concerned court has rejected the same, rejection of which has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that if one opportunity is granted on a particular day fixed by the concerned court, the examination would get concluded and would not seek any further adjournment. The learned counsel P.D. Surana would accept the same, but would add in contention that an application seeking appointment of a court commissioner is also pending before the concerned court. Would seek leave of this court to file an application for seeking appointment of a court commissioner. The concerned court shall consider the said application on its merit and pass necessary orders in accordance with law. In the light of the consensus with regard to the examination of DW1, I deem it appropriate to dispose the petition with a direction to the concerned court to fix a date for examination of DW/RW1 before RW1 and conclude the examination on the said date. It is made clear that this would be the last straw of opportunity to the respondents seeking examination or otherwise of DW1 before the in the subject FDP. In the light of the aforesaid,
For determining mean profits, commissioner may be appointed.
ಅದನ್ನ application ಅಲ್ಲಾಕಿ. Yes.
Actually, ಇಲಾಖೆ
ನಾ ಹೆಂಗ್ ಅವ್ರು ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ, ನಾನು ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
For the aforesaid reasons, the following got. The writ petition is disposed, so and so order stands quashed. The petitioner is permitted to examine DW1 and complete his examination on a particular day fixed by the concerned court. It is made clear that no further application.
Also, respondents may also file an application. Liberty to.
1 minute. It is made clear no further opportunity would be granted to the petitioner to file an identical application now filed before the concerned court. The respondent is also at liberty to file an application seeking appointment of a court commissioner
Determine the mean profits.
as the same is filed before this court. And for the purpose for which it is filed before this court. And the
Mean profit to determine.
ಇಲ್ಲಿ ಏನಕ್ಕೆ ಹಾಕಿದ್ದೀರಾ ಸರ್?
Mean profits determine ಮಾಡಿ.
ಅದನ್ನೇ ಹೇಳಿ.
ಮಾಡಕ್ ಬರಲ್ಲ, ಅದು ನಾವೇ ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬೇಕು ನಾವು. ಕಮಿಷನ್
ಮಾಡಿ ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ಲಾ ಅಷ್ಟೇ. ಡಿ ಹಾರ್ಸ್ ಲಾ ಏನಿಲ್ವಲ್ಲ. ಲಿಬರ್ಟಿ ಟು ಫೈಲ್ ಅಂತ ಹೇಳಿದೀನಿ, ಹಂಗಂತ ಕೋರ್ಟ್ ಶುಡ್ ಅಲೋ ಅಂತ ಹೇಳಿದೀನಿ. ಎಸ್, ಲಿಬರ್ಟಿ ಟು ಫೈಲ್ ಅಪ್ಲಿಕೇಶನ್ ಅಂದ್ರೆ ಕೋರ್ಟ್ ಶುಡ್ ಅಲೋ ದಿ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ. ಎಸ್, ಎಲ್ಲಿ ಇವರು 3:30.
Just only one submission. Not this, though may not in this affidavit that my learned senior friend submitted now. They admit, my lord, that there is a contempt, but I am not on that. But in the earlier affidavit that they filed, not in the writ petition, the states stated, not that in compliance with the direction issued by this honorable court in the division bench, where not the may I just not bring to your lordship kind notice. In the rejoinder that I have filed, but I have brought to your lordship's kind notice.
No, Prasanna Kumar sir, all this you are
No, I know,
seeking in a review petition, I will not entertain.
My only request is, I will not challenge anything now.
Garbage should get
Yes, of
cleared.
course, it must be
For
clear.
that, this petition should get cleared.
Definitely, yes. All that I am saying is, I have absolutely no objection for them to call for new tender. But let it be in accordance with the affidavit that they have filed. That's only my submission.
Yeah, that's okay.
Your end, model 89 itto. Again, second call was 89. Now what they have done, instead of 89, they have made into 33, which goes contrary to the guidelines issued by the division bench. Ashte mattinnenilla.
That they will do. They'll
Ashte, that's all is my request.
No,
89 they will have to
no,
call,
no,
not 33.
That is not the issue here, my lord.
No, I will, ಈಗೇನು affidavit ಕೊಟ್ರಲ್ಲ, ಅದ್ರ timeline ಕೊಟ್ಬಿಟ್ಟು I will close it. Otherwise, there is no ground for
But I
all over,
understand.
hearing all over again, no.
But I will only bring to your lordship just one line, what division bench has said, page number 200, of my rejoinder. But in the writ appeal, what the division bench was pleased to not direct them.
Seeking review of your.
ಇಲ್ಲ ಒಂದೇ ನಿಮಿಷ, I am not challenging anything now. I will not challenge anything. Page 27 of the rejoinder order starts, the honorable division bench.
More than 5 packages.
ಅಷ್ಟೇ. ಅದರಲ್ಲಿ out of 89. 89
ಅದು ಮಾಡ್ದಾಗ ನೋಡೋಣ. Yes.
So now what they have done, but they have issued now call for tender for 33 packages.
That's not the point here, my lord. Your lordships have passed certain directions. We have complied with it and have placed it before your lordship, compliance of your lordship's direction. Rest of it is not the subject matter.
The petition is preferred. The subject review petition is preferred seeking review of an order passed by this court on 22nd April 2025. This court, while disposing the petition, had issued certain timeline to the respondent respondent authority to conclude the process of tender within a time frame. Page 232, 233, quote ಮಾಡಿ. The review petition is preferred on the score that the respondents have violated the order by calling for tender all over again. Therefore, this court had stalled the action of another tender being called. The learned Advocate General has today filed an affidavit accepting the fact that the earlier the directions of this court as quoted supra would be adhered to without any deviation.
Deviation ಹೇಳ್ತಾರೆ ಅವರೇ.
Let your lordship
para
make-
6 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅವರೇ.
No, what your lordships are saying,
33.
page 4 of my affidavit may be kind. Page
Today's
4.
affidavit.
1 minute.
Today's affidavit may kindly be seen.
Page 4, my lord. There's no deviation, my lord.
Page 3 para 6 ಅಲ್ಲ ಅವ್ರು ಬರ್ದಿದ್ದಾರೆ, ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಅವ್ರು
Yeah,
ಬರ್ದಿದ್ದೀನಿ. I state the respondent herein seeks to comply with the judgment of this court having issued fresh tender inline is so and so with only 2 slight modifications.
No, kindly read it, my lord.
Firstly, the 4 packages so and so was made into 2 packages due to non-availability of land. Secondly, the above said tender excludes the scope of primary collection of municipality solid waste from door to door for the entire tender period. Now kindly see the earlier affidavit that they filed. That's all not is.
No, your lordship, in fact, my lord.
So the affidavit of the state in affidavit of the authority of the Bangalore Solid Waste
Solid waste.
Management Limited is as follows. Now quote this again, if you deviate from this,
My lord, in fact,
So,
my lord. it
page
is-
1 to 5.
I'm sorry for interruption. Not this para 29 of the earlier
No,
affidavit.
I will answer that also. So the learned counsel for the petitioner submits that it is contrary to the earlier affidavit. Therefore submits that the review petition should be heard on its merit. If the submission of the counsel for the petitioner is now considered, it would amount to rehearing of the entire matter all over again, except the aforesaid clarification that is already rendered. Rehearing of a matter which is disposed on its merits in the garb in the rehearing of the matter in the garb of entertaining a review would be sitting in appeal over the order that is passed by this court. Therefore, the review petition at any time filed should meet the test as laid down by the apex court in the case of Kamalesh Verma versus Mayawati, 2013 ATCC page 320 para 20.1. The apex court has laid down postulates as to when the review petition should be entertained and when it should not. The clauses that the clauses that would indicate that the review petition would not be entertained squarely applies to the facts of the case at hand, as the submission of the learned counsel for the petitioner, if entertained, would fall foul of the postulates so laid down by the apex court. In the light of the aforesaid, while cautioning the respondent that they would not deviate from what is produced today, the petition stands disposed. In the same term, review petition stands disposed. Yes.
All the affidavits or filed, they
My
filed.
lord, one,
Is for
yeah,
89
the matter
packages.
is over.
Suddenly,
What I want to point out, my lord, just divorce this matter. My learned friend is not eligible. He will not participate in this tender at all, my lord. It's
That's
only,
no, that is their purpose
No,
ultimately.
not purpose.
None of us should
No,
participate.
Not in, no.
None of us should participate is the ultimate
Let me know.
purpose.
Pursuant to your lordship directions, what we are doing is they're not eligible.
ನೀವು ಅದಕ್ಕೆ ಬೇರೆ ಏನು ಹಾಕ್ಬೇಕು, ರಿವ್ಯೂ ಹಾಕಿದ್ರಾಗ.
And then, because that is
The
the
lordship
point. my lord.
directed that all of us can participate.
No.
By virtue of this 33, none
They
of us can participate.
33
Challenge that.
They don't want to challenge that. That's the point, my lord. In the garb of review, they're challenging something else which we are complied.
With slight
And insofar
modification.
as 33
Slight modification according to them.
No, insofar as 33.
Light.
Slight modification.
And insofar as 33, they are eligible, my lord. What my learned, there are 28 assembly constituency, my lord. Each assembly.
ಇದನ್ನ ರಿವ್ಯೂ ಎಂಟರ್ಟೈನ್ ಮಾಡ್ಬಿಟ್ರೆ then it's
No, the
going to
why,
open Pandora's.
just to satisfy your lordship, my lord, why we did 33 is, my lord, there are 28 assembly constituencies. Each assembly, we made it as a package. In some of the constituency are larger, so we made 2 packages. They can participate in.
Just to exclude us, that's all.
Not exclude, they're eligible.
None of us
ಅವರೇ
can
ಹೇಳ್ಬಿಟ್ರೆ
participate.
ಅವರೇ ಹೇಳಿದ್ರಲ್ಲ, each assembly one package.
My lord, no, what they wanted is, my lord, so it becomes convenient for the public, my lord.
ಹಂಗ ಅದು ಪೂರ್ತಿ ಹೇಳಿಲ್ಲ ನೀವು, each assembly one package ಅಂತ.
ಅಲ್ಲ, ಏನ್ ಅವ್ರಿಗೆ ಪಬ್ಲಿಕ್ ಹೆಂಗ್
My lord,
ಕನ್ವೀನಿಯಂಟ್ ಆಗುತ್ತೆ
ultimately, my
ನಮ್ಗೆ
lord,
ಗೊತ್ತಾಗಿಲ್ಲ.
they are eligible to participate in these 33 packages which were they are eligible, and they're doing it. And one other thing, my lord, nobody else can, I mean, they've been doing it for so many years. There are only few people who are specialized in doing this work.
Specialized in garbage lifting.
Garbage, absolutely. That's what I saw first time. Only garbage, actually.
All right, yes.
My only concern was
You
not affidavit that they have filed.
Take the
before this on
cue.
will go on.
You should not file review.
Please.
Gershut.
I'm sorry. I am not your lordship. Can I seek for a clarification that this dismissal of review not come in the affect my right not to challenge?
That is always open.
Review dismiss ಆಗಿದೆ ಅಂತ they should.
Dismissal of the review will not come in the way of the petitioner's
Seeking
right
redressal.
to agitate the process of tender or otherwise.
Please,
That is always
please.
open. It is needless to observe. It is needless to observe that the dismissal of the subject review petition would not anyway preclude the petitioners or any person to call in question the process of tender if they are so aggrieved.
Please.
Yes. ಹೌದೆಲ್ಲ ಮೇಡಮ್ ಸೀನಿಯರ್ ಪ್ರಸನ್ನ ಕುಮಾರ್ AG ನಿಮಿಷ. ನೆಕ್ಸ್ಟ್ ಬಿಟ್ಟು ಅರ್ಜನ್ ಆಯ್ತಲ್ಲ ಮೇಡಮ್. ಯಾವತ್ತು ಇಂಟರ್ ಮಾಡ್ರಿ ಇರೋದ ಇದೆಲ್ಲ 28 ಎಲ್ಲ 82, 80, 83 also.
84.
I appeared for the respondent in 84, my lord. WP 2863.
ಅದೇ ಗೊತ್ತು ಅದು that petition is still pending.
My petition may be allowed. My submission is.
Yeah, ನಿಮ್ಮ petition may be allowed. ಯಾವ್ದದು?
2863 of 22. I appear for the petitioner. The application filed to produce the document is rejected. At page 39 is the order.
We will allow that.
I am not a party in that.
So lords,
Who is the
there is
respondent?
extreme
Let us
delay in
come.
filing this application. It is not yet. Yes, my lords.
Yeah, order 18 rule
I appear for
17.
the respondent.
ಯಾವಾಗ?
Yes, my lords.
Produce the documents, order 7 rules 14 application.
714 yes.
714(3), page 20, IA number 1217.
Hmm.
One is the certified copy of the order sheet. The other is the certified copy of the sale deed.
So what if it is produced?
No, my
That
lords,
is
the
rejected
certified
now.
copy of the
It is
order sheet.
rejected.
Yes. It's certified copy of the order sheet in some other case.
How
Not
that is
relevant to this
So
relevant.
what?
case.
He wants to rely on that. So what?
No, my
Mere
lord,
marking
there
of a
should be
document
relevant-
will not amount to its proof, sir. It still have to be proved.
But yet the relevancy will have to be proved before it is taken on record.
I'll argument ಮಾಡ್ಕೊಳ್ಳೋದು.
That's my submission, my lord.
We'll allow this. 84.1. The petitioner, ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್ 84.1. ನಿಮ್ದು ಒಂದು ನಿಮಿಷ. We'll come back to you.
WP 2863.
28?
2863.
2860 of 22.
Yes, sir. The petitioner is the plaintiff in OS
8345.
8345 of 2010. The plaintiff files an application under Order 18 Rule 17.
Order 7
Oh,
rule.
sorry,
14.
Order 7 Rule 14 to produce 2 documents. Certified copy of another.
Order sheet in OS 2802 of 2004.
ಆಮೇಲೆ
Certified copy of sale deed dated 4/9/23.
ಮೇಡಮ್.
Page 29.
So and so. The concerned court, in terms of the order impugned, rejects the same on the score that the relevancy of production of those documents is not stated. The learned counsel appearing for the petitioner PD Surana submits that those certified copy would be required for the defense of the petitioner, and the reason for filing the application for production of the said documents is clearly brought out in the affidavit. The learned counsel for the respondent would submit that those documents that the petitioner seeks to place on record now through the application is not concerning the present suit. Therefore, it is of no relevance to bring those documents into the subject suit. I have given myself. The aforenarrated facts lie in a narrow compass. The petitioner plaintiff files an application as observed here and above under Order 7 Rule 14 of the CPC, seeking production of the aforequoted 2 documents. The documents, according to the petitioner as averred in the affidavit, is necessary for his defense. His defense or to suit for what?
Suit for declaration.
Suit for permanent injunction.
Is necessary in aid to the suit so filed for declaration. The affidavit of the petitioner filed.
Pure injunction, no declaration.
Injunction.
ಅಷ್ಟೇನಾ? For injunction, yes, not declaration. So and so. The affidavit filed by the petitioner is as follows, page 31 to 33.
30 to 30.
While it cannot be said that the affidavit so filed by the petitioner did not contain any reason for production of the said documents, in the light of the reasons so rendered, the order of the concerned court rejects the application on the score that there is no relevance brought out is unsustainable. The unsustainability of it would lead to its obliteration. for the aforesaid reasons, the following order allowed, quashed. The petitioner is the application so filed by the petitioner is allowed. The documents so sought, i.e. 2 in number, are permitted to be placed on record. The concerned court is at liberty to regulate its procedure thereon, ordered accordingly. ನಿಮ್ದೆ They vacate ಆಯ್ತಾ?
ಕೇಸ್ 33 ಈಗ ಕನೆಕ್ಟೆಡ್ ಕೇಸ್ ಅಲ್ಲಿ ಸ್ಟೇ ಇರೋದ್ರಿಂದ ಫಸ್ಟ್ ಕೇಸ್ ಅಲ್ಲಿ ಇರುವಂತ ಕೇಸ್ ನಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ ಅಂತ ಬಂದಿತ್ತು. Now that the stay has been vacated.
Which stay?
This matter. Just now my lords dictated.
ಓ ಇದು ಅದ್ರಲ್ಲಿ ಇದು ಸ್ಟೇ ಬರ್ದಿದ್ದ. ಹಾಗಾದ್ರೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿ ಬಿಡಿ.
No, my lord, there is no stay.
In the light of the petitioner is before this court, calling in question an order dated 14/3/2025, rejecting an application filed by the petitioner IA 13 and 14 under Order 39 Rule 4 and 7, Order 13 Rule 4 and Order 7 Rule 11 of the CPC. The concerned court had rejected the said application to be considered.
Will not consider because of
The
the stay.
concerned court refused to consider the said application on its merit on the sole score that there was an interim order operating in the companion petition. The companion petition is now disposed. The companion petition was concerning production of a document and therefore further proceedings had remained stayed. In the light of the disposal of the companion petition, the impediment that is projected by the concerned court to consider the application filed by the petitioners on its merit is no longer in subsistence. Therefore, the concerned court shall now pass necessary orders in accordance with law after affording opportunity to all the parties to the list on IA 13 and 14 before the concerned court.
Companion suit ಅಂತ ಬರುತ್ತೆ.
Companion suit ಅಂತ. Yes. Petition ಬೇಡ suit. ಅಷ್ಟೇ ಅಲ್ಲ? ಇಷ್ಟಕ್ಕೆ 2010 ಇಂದ.
Petition ತರಿಸಿದ್ದಕ್ಕೆ ನಮಗೆ ರಿಲೀಫ್ ಸಿಕ್ತು ಸರ್.
ಆಯ್ತು ಸರಿ. Next.
I appear for the respondent in this
For petitioner, my lords. Order 18 Rule 17, my lord. Recalling the
ಯಾರನ್ನ?
PW1, my lord, for further chief examination, my lord.
ಎಷ್ಟು ಸರ್ತಿ ಆಗಿದೆ?
ಇಲ್ಲ, after first time.
After how many years?
2018.
After completion of defendant's evidence, an application with vague this thing they have filed. Documents produce ಮಾಡಬೇಕು ಅಂತ application ಹಾಕ್ತಾರೆ. Which documents? Nothing is forthcoming in page 66.
ಈಗ examination and documents are.
Examination to produce documents.
Produce documents.
Yes, to produce what documents?
Nothing is forthcoming.
Not unfortunately has not placed any
Unfortunately,
list of documents, my lord, at the time of
then
filing
it
of
goes,
application.
File a fresh application with all the details if you want to.
My lord, kindly appreciate.
Otherwise, ಇದ್ರಲ್ಲಿ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
It's not for production of
If
documents.
you have forgotten examination,
yes,
without
please, my
document, if you have forgotten to place that itself, you won't file a fresh application with reserved liberty.
Please, my lord.
Yes, the petitioner is before this court seeking the following prayer. The learned counsel for the petitioner, after arguing the matter at length, would seek leave of this court to withdraw the subject petition and the application so filed before the concerned court, reserving liberty to file a fresh application on the same cause of action, as the petitioner out of inadvertence has not placed the list of documents that he wants to be placed before the court, through whom the witnesses would speak. Through whom the witnesses would speak. Therefore, reserving such liberty, the petition stands disposed. Yeah, next.
My lords, earlier order, my lords.
ಏನು? Stay ಇದೆಯಾ?
Stay ಇತ್ತು.
Documents ಹಾಕಿ ತೊಂದ್ರೆ ಇಲ್ಲ.
Please, my lord.
Immediately file ಮಾಡಿ. We'll release the order tomorrow itself.
Please.
Next.
First petition to recall the PW2 for cross-examination is rejected by the.
1817.
Yes, sir.
Order 18 Rule 17.
Yes.
ನಿಮ್ದೇನ್?
Several opportunities were provided to the defendant lords to cross-examine the PW1.
ಎಷ್ಟು ದಿನ, ಎಷ್ಟು ವರ್ಷ?
Lord, it was the suit of the year 2018 converted into commercial suit in the year 2021.
Commercial OS,
How? 2021.
Yes.
No rent has been paid, Lord, so far since 2018. 70,000 was the rent. Lord, 80,500 Lord, as of now, Lord's rent. Nearly about Lord's 20 lakhs Lord's is due. Neither he has deposited nor paid. Lord,
Regarding the submitting regarding PW1, my lord, which is
ನೀವು ಯಾರು?
PW2 cross.
PW1 Lord has died. PW1 has died.
PW2 only
Therefore,
once we-
PW2 not is,
Only
PW2
once
ಯಾರು?
PW2
the plaintiff, LRs.
ಎಲ್ಲಾರ್ಸ್.
Yes, ಅವರಿಗೆ ಒಂದ್ಸಲ ನಾವು ಹೆಲ್ತ್ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀವಿ. ದಟ್ ಅಪ್ಲಿಕೇಶನ್ ಇಸ್ ರಿಜೆಕ್ಟೆಡ್.
ಈಗ ರೆಂಟ್ ಕೊಡುದಿಲ್ಲವಾ?
Rent ಕೊಡ್ತಾ ಇಲ್ಲ, ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಕೊಡ್ತಾನೂ ಇಲ್ಲ.
I will permit.
7 years.
No, I will permit cross examination subject to rent.
Please.
ಕೊಡ್ತೀರಾ? ಇಲ್ಲ petition dismiss ಮಾಡುವ.
ಇನ್ಫಾರ್ಮೇಶನ್.
ಇನ್ಫಾರ್ಮೇಶನ್ ಏನ್ ಬೇಡ, ನಾನು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತೀನಿ, ಅದೇ ಇನ್ಫಾರ್ಮೇಶನ್.
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡ್ಬಿಡ್ತೀನಿ. Otherwise I will.
ಈ ರೆಂಟ್ ಪೇ ಮಾಡಿದ್ರೆ ಸುಮ್ಮನೆ ಸ್ಕ್ವಾಟಿಂಗ್ ಓವರ್ ದ ಪ್ರಾಪರ್ಟಿ ಅಂಡ್ ಫೈಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಅಂಡ್ ಡ್ರ್ಯಾಗಿಂಗ್ ದ ಪ್ರೊಸೀಡಿಂಗ್ಸ್, we will not entertain all that.
Lodging house.
You should come out with bona fides. Yes.
42 rooms are there. my lord.
42 rooms are there.
2 days time. I will.
Friday.
Yes.
List on Friday. If nothing is there, we'll dismiss it straight away. We can sustain the order or allow the petition, both. Yes.
Yes.
88 covered. BWSSP. Yes.
That is pertaining to pro rata charges, my lord.
Correct, sir. BWSSP disposed.
Lord, High Court in division bench.
Oh,
ನೆನ್ನೆ ಮೇಡಮ್ ನಿನ್ನೆಯಿಂದ ಇವತ್ತಿಗೆ ಅರ್ಜನೆ ಕಾಪಿ ಸೌಂಡ್
ಎರಡು ಸೂಟ್ ಹಾಕಿದೆ, ಎರಡು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ.
ಇಲ್ಲ ಮೇಡಮ್, ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ 2 ಕಾಪಿ.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ?
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ.
ಕ್ಲಿಯರ್ ಪಿಟಿಷನ್ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಪ್ರೆಸೆಂಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಇವರು.
ಬರ್ಲಿ ಮನೀಶ್ ಕುಮಾರ್. ಎಸ್, ಪಾಸ್ ಓವರ್. ಪ್ರದೀಪ್ ಕುಮಾರ್ ಇದಾರ? ಮನೀಶ್ ಕುಮಾರ್ ಯಾರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ?
ಮನೇಶ್ ಕುಮಾರ್ ಅವರು.
ಎಸ್, ಲೆಟ್ ಹಿಮ್ ಕಮ್. ಇಫ್ ಯು ಫೈಂಡ್ ಹಿಮ್, ಆಸ್ಕ್ ಹಿಮ್ ಟು ಕಮ್. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Petitioner in this case, madam. The trial court had granted temporary injunction to order 39 rule 1 and 2, and we had appealed against the order of the trial court under
Where is
NA.
the order of the first appellate court?
First appellate court order was passed on 29. No, first appellate court they dismissed our MA.
Produce a certified copy. ನೀವೇ ಟೈಮ್ ತಗೊಂಡಿದ್ದೀರಾ? Where is that?
This is the order copy of the trial court, my lord, under OS 29/1. I've marked in.
Police protection.
No. In the same order, point number 1, my lords, I've marked in pen, blue color pen. So later they had asked for police protection because the first appellate court had dismissed our petition. Point number 1.
Where is application is not even decided? Your case is not even decided.
No, it is still pending adjudication, my lord. I have come under the order that temporary injunction was granted, but I am in the possession of the property. So, but he has filed for, the respondent there has filed for the permanent injunction. So,
You are the defendant, is it?
yeah, I am the defendant in OS 29 of 2024.
What is Poultry?
Yeah, it is Poultry, my lord.
What? Yeah.
Sorry, I apologize.
Yes.
So it is a poultry of 35 kuntas and 15 kuntas. So he is the owner. The respondent here is the owner.
Right. Where did you get this ostrich?
So we got it imported from Tamil Nadu. Sorry, we
Tamil
got it
Nadu?
from Tamil
Imported
Nadu. Yeah.
from Tamil Nadu.
So there is an near, I think, Dindikal or Salem, if I'm not wrong. So they,
Ostrich.
yeah, yes, the ostrich eggs are being imported to Tamil Nadu. From there we do it in our
They're
poultry.
permitted to do so.
We have the permission.
Howda?
So I'm in the possession of the property, and even in the first appellate court, I've produced all the documents there, including the government veterinary doctor's certificate, certifying that he comes regularly and he is the doctor for my poultry. Then we even
Now injunction is granted to the plaintiff.
yeah. So I apologize, my lord. I apologize. I stand corrected.
You're not in a restaurant. You're in a court of law.
I am the defendant in the OS court, in the OS suit, my lord.
Yes.
So there, against me, the temporary injunction is granted because he has filed false affidavits to show that I am not in the possession. Whereas I am in the possession of the property. Initially, it was on the sale agreement. I have taken the property on sale agreement. So to enforce my rights, I have already filed.
Where is the defendant, caveator? There is no representation behalf of the counsel representing the caveator. The counsel for the defendant in OS so and so has preferred the subject petition on the score that the first appellate court has not considered the case of the petitioner defendant for vacation of the order of temporary injunction granted in OS so and so, OS 29 of 2024 by the concerned court. The learned counsel for the petitioner has taken this court through the documents appended to the petition to demonstrate that he is in possession of the property and is running a poultry farm in the said premises. In that light, the petitioner, during the pendency of the first appellate court shall consider the application of the petitioner and pass necessary orders in accordance with law within. And we'll send it back or grant here?
No, we'll try
Let
to
him, let him come. Yes. In that light,
The MA petition has already been
in that light, if the petitioner is in possession of the property, the possession shall not be disturbed till the next date of hearing, awaiting the appearance of the counsel for the caveat or list the matter on 20th.
Much obliged.
My lord, in this case, my lord, petitioner, my lord, filed suit for partition, separate position, my lord. I have filed, but during the trial court has granted interim order not to alienate the property, my lord. As per order dated 27/4/2021, my lord. My lord, thereafter, my lord, the brother of the petitioner, my lord, behind the back of the petitioner, my lord, entered into agreement and obtained ex parte decree by referring the matter to the local adalat.
There is no representation on behalf of the caveator. List the matter on 3rd September, interim order subsisting will continue to the next date of hearing.
ಅಲ್ಲ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇನ್ನೂ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ.
ಹೌದಾ?
ಹೌದು, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಫಸ್ಟ್ ಟೈಮ್
ಕೊಟ್ಟಿಲ್ವಾ? ಏನೋ ಲಾಸ್ಟ್ ಟೈಮ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಅಂತ ಇತ್ತು ಅದಕ್ಕೆ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಅದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಮುಂದಕ್ಕೆ ರೀಚ್ ಆಗಿರ್ಲಿಲ್ಲ.
ಇದೆಯಾ ಮೇಡಮ್? ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇತ್ತಾ?
ಇಲ್ಲಲ್ಲ.
ಇಲ್ವಾ? ಯಾವ್ದು ಮೇಡಮ್? ಆಯ್ತು, awaiting his appearance list on 6th. Yes.
Right now the commissioner is appointed to execute the sale deed, my lord.
6th, if he doesn't come, we'll pass an order.
ಅಲ್ಲ ಅಷ್ಟರಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಇನ್ಫ್ರಾಕ್ಚರ್ಸ್ ಆಗ್ಬಿಡುತ್ತೆ. Despite
Further, the concerned court shall defer its proceedings till the next date. Yes.
Appear for the petitioner, my lord. Petitioner.
91.1. What is this?
This is the petitioner. He was the respondent before the FDP court, my lord. He filed an application for under Order 23, Rule 3. As during the pendency of the FDP proceeding, my lord, the matter was settled among the parties. So consequently, he filed an IA under Order 23, Rule 3, seeking the permission of the court to dismiss the FDP. And one more IA, my lord, he filed.
All the parties compromised or only a few?
All the parties compromised.
That is rejected now?
That is what has happened, my lord. Against the decree passed by the trial court allotted 1/3 share to all the 3 parties, my lord. Against that, a RFA was filed. And during the pendency of RFA, my lord, the matter was settled among the 3 parties, 3 brothers. And without informing the settlement, which they have entered into a compromise date, a memo was filed before the division bench and the appeal was withdrawn, my lord. And the FDP, in the meantime, FDP was pending before the trial court. And subsequently, my lord, the plaintiff petitioner before the FDP court, he continued with the FDP. And consequently, my lord, an application was filed before the division bench to recall the withdrawal memo filed in RFA, my lord.
Now what? Why are you here?
Now, my lord, and now what has happened, this petition, then before the FDP court, my lord, I filed a application under Order 23, Rule 3 to dismiss the FDP proceeding, and also filed one more application to see, due to the change of circumstances, to hold an inquiry before the FDP court. And both applications are rejected by the FDP court, my lord. And Against those orders, these two writ petitions are filed. And this writ petition is filed on 4th June 2025, my lord. And subsequently, the division bench restored the appeal on 6th June 2025. And it was posted on 28th July, my lord.
I you tell everything to the division bench.
Now it is posted for final hearing on
When?
1st September.
We'll post it on 3rd September then.
Very much.
List the matter on 3rd September. Yes, next.
The first respond.
No, this is defendant's writ and agreed by the order dated 2625 at page number 18, my lords, IA number 2, for production of additional documents under 1115, my lords. This is suit for money recovery. My lords, the case
Commercial
is-
OS.
My lords,
Commercial
commercial
OS.
OS, yes, my lords.
When was the written statement filed?
My lords, it was filed on the 7th of April 2025, my lords.
When did you file the application?
My lords, the application was preferred by them.
By them?
Yes, my
You
lords.
are, you are the defendant.
Yes, my lords. It's a defendant.
That is allowed.
The application has been allowed, my lords. My lords, the distinction.
Anything else, sir?
My lords, the distinction, my lords, over here is that the case of the petitioner is that the plaintiff respondent in this writ preferred an application to file additional documents, not as an answer to any case set up by the defendant subsequently to the filing of the plaint, my lords.
We'll take it as that only.
But my lords, no such reason has been given in the affidavit as well, my lords. They simply state that it was there in their possession and by oversight it could not be filed by them. That is the defense which is being taken by the plaintiff, my lords. My lords, under the circumstances, as my lords, in the judgment by my lords,
in a case there it was, there also there was no indication that we have filed these, we want these documents to come in on the defense setup. That was a submission made. I've recorded that submission. It is
my lords,
permissible.
as my lords held at page number 7, ex parte decree was already passed in this case, my lords. And on 2 counts, the evidence was being adduced by in this case, my lords.
What prejudice would ensue, sir? Nothing.
Lords,
Document mark, my, nothing is going to happen.
My lords, if
because
that
law
is-
permits.
3 documents, my lords, would basically go against the interest of the defendant, my lords.
Oh, that's exactly his point. Yes.
But my lords, that has not been taken as a ground when the affidavit was filed, my lords. As a matter of fact, if my lords,
Lord, as soon as he filed the written statement, he filed the documents. Earlier, we had already filed the documents which had already been marked as exhibits. It was an ex parte decree. Thereafter, he filed miscellaneous. Restore.
Anything else?
lords, as a matter of fact, I'm placing reliance on this judgment, my lords. Page
Could
number
you-
65. This is the exception clause, my lords, as my lords had held in my lords judgment. Paragraph number 14, my lords, page number 65, my lords. An exception clause is normally a part of the enacting section, unlike a proviso which follows an enacting part. Crawford's interpretation of laws speaks of exception as follows. Exceptions and provisos. The exception, however, operates to affirm the operation of the statute to all cases not exempted and excludes all other exceptions. That is, it exempts something which would otherwise fall within the general words of the statute. Next paragraph, my lords. It is a right that an exception clause has to be strictly interpreted and cannot be assumed but be proved.
I will not take exception to that exception at all. So don't worry. Anything else?
47, my lords, of the compendium of the judgment of my lords.
Compendium.
JSM. Page 47, my lords.
JSM.
Yes, my lords.
We'll follow
JSM.
that.
My lords, again, my lords has held that the statutory provision is couched in permissive and enabling terms and mandates that the plaintiff shall file a list of documents in its power, possession, control, and custody along with the plaint, but renders certain flexibility. It thus carves out exception to the general mandate of early disclosure. Subclause C directs that nothing in this rule shall apply to the documents produced by the plaintiffs and relevant only for cross-examination of defendant's witness in answer to any case set up by the defendant, my lords. This is my only ground, my lords.
No exception to your submission also, but can't help. Yes, dismissed. Vijay. Yes. Next.
I appear for petitioner. Lord, petitioner is the plaintiff. Lord, as per annexure F and H, Lord, the impugned orders passed by the Lord, trial court and also first appellate court. Lord, on the application on IA number 2.
What is that?
Lord, it is, my lord, not to put up any construction without leaving, my lord, setback or encroachment of 4.5 feet vacant space belong to the plaintiff. My lord, one Tippegowda. Tippegowda had two sons. My lord, one is, my lord, Sannegowda alias Sannaya, and another is Kenchegowda alias Kencheya. My lord, plaintiff is the son of, my lord, Sannegowda.
Neev yaru?
Plaintiff is the son of, my lord, first son
You are
Sannegowda.
plain Gopala.
Yeah.
Yes.
Second, Gopala is the son of Kenchegowda. Lord, both are brothers' sons. Lord, your lordships kindly see for a moment annexure A. Lord, there was a partition between the, my lord, fathers of the plaintiff and first respondent.
ಈಗ ನೀವು ಬಂದಿರೋದು ಇಂಜಂಕ್ಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ಅದೇ ನಾನು
ಅಷ್ಟೇ, ಅದಕ್ಕೆ ಯಾಕೆ
ಈಗ ಕನ್ಕರೆಂಟ್ ಇದೆ.
Suit
ಅದರಲ್ಲಿ
argue
one
ಮಾಡ್ಬೇಡಿ.
suit filed by the, my lord, plaintiff himself. My lord, I am the plaintiff. My lord, this annexure A, my lord, a house property was allotted. East to west ನನ್ನ ಫಾದರ್ಗೆ 8.5 ಗಜ ಅಂತ ಹೇಳ್ತಾರೆ.
Both the courts have not believed your version.
ಅದು ಯಾಕೆ ಅಂತ ಹೇಳ್ತೀನಿ ಅಂದ್ರೆ ಅವರೇನೆ ಒಂದು ಸ್ಕೆಚ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಇವಾಗ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಕೈಂಡ್ಲಿ ಸಿ 8.5 ಗಜ ಅಂದ್ರೆ 25 ಅಡಿ ಆಗುತ್ತೆ. 25 ಅಡಿಗೆ ಅದೇನಾಗುತ್ತೆ ಆಫ್ಟರ್ ಡೆತ್ ಆಫ್ ಮೈ ಫಾದರ್, ಮಲಡ್ ಪಂಚಾಯತ್ ಅಫಿಷಿಯಲ್ಸ್ ಮಲಡ್ ಇನ್ಸ್ಟೆಡ್ ಆಫ್ 25.5 21 ಫೀಟ್ ಅಂತ ಹೇಳ್ತಾರೆ.
So problem is 3.5 feet, 4.5 feet.
4.5 feet.
4.5
ಫೀಟ್ ಅಲ್ಲಿ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ಅದ್ರಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ ಮತ್ತು ದನದ ಕೊಟ್ಟಿಗೆ ಅಂತ ಹೇಳ್ತಾರೆ.
4.5 feet ಅಲ್ಲಿ ದನದ ಕೊಟ್ಟಿಗೆ ಇದೆಯಾ?
ಅದು ಹೇಳ್ತಾರೆ. ಅದನ್ನ ಅಷ್ಟೇನೆ ನಾವು ವಿ ಆರ್ ಕ್ಲೈಮಿಂಗ್. ಅಲ್ಲಿ ಏನು ಮಾಡೋದ್ ಬೇಕಾಗಿಲ್ಲ. ಅದು ದಟ್ ಈಸ್ ದಿ ಓನ್ಲಿ.
ಅಲ್ಲೇ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ದಟ್ ಈಸ್ ದಿ ರೀಸನ್ ಮರಾಡ್. ಅಲ್ಲಿ ಏನಾದ್ರು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆದ್ರೆ ಆ ಸ್ಕೆಚ್ ಪ್ರಕಾರ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಫಾರ್ ಎ ಮೂಮೆಂಟ್.
ಈಗ ನೀವು ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಲ್ಲಿ?
ಆಲ್ರೆಡಿ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್.
ಏನ್ ಕಟ್ಟಿದ್ದೀರಾ?
ಬಿಲ್ಡಿಂಗ್.
ಬಿಲ್ಡಿಂಗ್ ದನದ ಕೊಟ್ಟಿಗೆ ಅಂತ ಇದಾರೆ, ಬಿಲ್ಡಿಂಗ್ ಅಂತ.
Building has been constructed, my lord. Produce the photographs, my lord. For a moment, kindly see, my lord. And also, I will give on the setback also, my lord. In the photos, as clearly.
Let the court consider.
ಅದು ಏನಾಗಿದೆ ಮೆಜರ್ಮೆಂಟ್ ಅಂತ ಈಗ ಇದು
you pass any you know file any application you want for that, the court will consider. We will not get into
ಏನಾಗಿದೆ
this.
ಅಂದ್ರೆ ಇದು ಈಗ ಈ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ, ಇಲ್ಲಿ 7.5 ಅಡಿ ಇದೆ, ಈ ಕಡೆ 5.25 ಅಡಿ ಇದೆ. ನಡುವೆ ಏನಾರ ಕಟ್ಟಿದ್ರೆ ನನಗ್ 4.25 ಅಡಿ ಸಿಗೋದಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ಅದಕ್ಕೋಸ್ಕರ ಬ್ರದರ್ಸ್ ಮಕ್ಳುಗಳು ಅವರೆಲ್ಲ ಸುಮ್ನೆ ಇದು ದಟ್ ಈಸ್ ದಿ ಓನ್ಲಿ ರೀಸನ್ my lord I felt
the court will mount.
What the petitioner is claiming, my lord, not comes to the property of the dependents, my lord.
What property?
Property of the dependents.
Property.
ಅಲ್ಲ, ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ 8.5 ಗಜ ಅಂದ್ರೆ 25.5 ಅಡಿ.
We will not entertain the suit here.
My lord, that application only, my lord, ಅಲ್ಲಿ ಏನು ಫೌಂಡೇಶನ್ ಆಗದೆ ಇರೋ 4.5 ಅಡಿನಲ್ಲಿ ಫೌಂಡೇಶನ್ ಆಗದೆ ಇರೋ ತರ ಅಟ್ಲೀಸ್ಟ್ ಟು ದಟ್ ಎಕ್ಸ್ಟೆಂಟ್
ಆಗೋಗಿದೆ ಎಲ್ಲ ಫೌಂಡೇಶನ್.
ಇಲ್ಲ ಫೌಂಡೇಶನ್ ಏನು ಹಾಕಿಲ್ಲ.
4.5 ಅಡಿಲಿ ಏನು ಮಾಡಿಲ್ಲ ಅಂತ ಅವರೇ ಹೇಳ್ತಾರೆ.
ಹೌದು, 4.5 ಅಡಿ ಏನು ಮಾಡಿಲ್ಲ. ಮುಂದೆ
ಮಾಡಲ್ಲ ಬಿಡಿ.
ಅದನ್ನ ಟು ದಟ್ ಎಕ್ಸ್ಟೆಂಟ್ my lord,
That extent is disputed, my lord. Let them be decided.
That extent, my lord, other ಅದೇನು
want to construct in that 4.5 feet.
I'm not
that can be
ಅಷ್ಟೇ.
ಅದನ್ನೊಂದು ಮಾಡಿ.
The learned counsel appearing for the petitioner is before this court calling in question concurrent finding of both the trial court and the first appellate court, which have declined to grant any temporary injunction in favor of the petitioner. The issue in the list revolves around 4.5 feet space which abuts both the property of the petitioner and the defendant. The learned counsel for the petitioner's apprehension is that if no interim injunction is granted, the defendant would defendant would construct the property utilizing the 4.5 feet space as well. The learned counsel for the respondent submits that the building is already come up and the 4.5 feet is not in, is left vacant. Left vacant would not be doing so, would not be taking up any construction during the pendency of this suit. It is for the concerned court to decide the issue with regard to 4.5 feet. The submission of the learned counsel for the respondent merits acceptance. In that light, recording his submission as observed here in above, the petition stands disposed. Yes.
The matter was listed yesterday.
Acquisition of lands in
May make submission.
Dabaspet, my lord.
Dabaspet?
Dabaspet, that's a Solur and Dabaspet in Bangalore
Yesterday,
Rural District.
yesterday, my lord, one case was listed, my lord, that is WP number 19922.
In this matter.
Lord,
Yesterday it was submitted.
ಎಲ್ಲ yesterday listed ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಮುಂದೆ ಹೇಳಿ.
Earlier to this petition, one more petition was filed by the petitioner was the submission yesterday.
So, my lord, your lordship, my lord,
Prior to this
directed.
petition, my lord.
ಆಯ್ತು, ಯಾವ್ದು ನಂಬರ್ ಕೊಡಿ.
ಅದೇ ಎರಡು ಬಂದಿದೆ ಇವತ್ತು.
ಬಂದಿದೆಯಾ ಇವತ್ತು?
ಹಾ, ಇವತ್ತು.
Therefore, my lord, the petitioner seeks to withdraw this petition, my lord.
97.
Because earlier a petition was already made. What happened in that
So
matter?
ಇವ್ರು ಹಾಕಿರೋದು ಹೇಳಿದೆ ನಿಮ್ಗೆ.
ಅವ್ರು ಹಾಕಿರೋದ್ರಲ್ಲಿ ಇವರು
47
ಇದ್ದಾರೆ.
petitioners were there. The villagers gathered, my lord, aggrieved persons gathered, signatures were taken.
Gathered and signature taken.
Yeah, you know, 6 days before filing this petition, that petition came to be filed, not as if interim order was not granted and
ಅದಕ್ಕೆ
therefore
ನಾನು ಹೇಳ್ದೆ 1 ಲಕ್ಷ 2 ಲಕ್ಷ ಅಂತ, ಅದಕ್ಕೆ ಈಗ ವಿಡ್ರಾ ಮಾಡ್ತಾರೆ.
permitted to be.
Learned
Pursue the earlier petition.
ಹಾ?
And pursue the earlier petition that is filed.
ಅದ್ ನಿಮ್ದ?
Withdraw this petition.
ನೀವ್ ಹಾಕಿರೋದ earlier?
That's mine is 49 members, they have filed it, my lord. Are the landowners of.
ಯಾವ್ದ್ರಲ್ಲಿ ರವಿ ಇದು?
My
ನೀವ್
lord,
ಹೇಳ್ತಿರೋದು ಈಗ?
19922 of 25.
97.1.
97.1. That is 18553.
18553 is mine, my lord. It's mine.
ನಿಮ್ದು ಯಾವ್ದು?
19922
19922 of 2025.
97.1.
97 sir.
97.
97.1 ಶಿವಪ್ರಕಾಶ್.
ಹೌದು.
The learned counsel appearing for the 97 ಅಲ್ಲಿ counsel appearing for the petitioner.
ಕಾಸ್ ಚೇಂಜ್ ಆಗಿದೆ. ಕಾಸ್ ಲಿಸ್ಟ್ ನಮ್ಮ ಕಾಸ್ ಲಿಸ್ಟ್ ರಿವರ್ಸ್ ಆಗಿ. ಗೊತ್ತಿಲ್ಲ.
The learned counsel for the petitioner in WP 19922 of 2025 files an application seeking, files a memo seeking withdrawal of the petition. The memo reads as follows. In the light of the said memo, without the light of the said memo, petition is disposed as withdrawn.
But I suppose my petition is concerned.
Dabaspet.
Respondent have taken time of almost.
ಅದು ಇವತ್ತು ಬಂದಿದ್ದು ಇದಕ್ಕೋಸ್ಕರ ಬಂದಿದ್ದು, ನಾವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀವಿ ಟೈಮ್ ತಗೊಂಡಿದ್ದು.
Objection.
ಅಲ್ಲ ಇದು
ಹಾಕ್ತೀರಾ?
ಡೇಟ್ ಕೊಟ್ಟಿತ್ತು
The
ಅಬ್ಜೆಕ್ಷನ್.
learned counsel appearing for the
Malad,
learned counsel H.L. Pradeep Kumar representing the respondent seeks 2 weeks time. 2 weeks time to file statement of objections. List the matter on 19th. Objections if any by then.
there is no interim prayer.
There is no interim prayer.
No interim prayer is there, no interim prayer is not granted because they objected.
After
Learned
hearing
Advocate
Malad, the
General
parties
has
will not,
objected.
No, there is no interim prayer.
Interim prayer I
There
pray-
is no interim prayer. Yes, 19th. Yes.
Malad, what happens is 28/4 is concluded. Now if there is no interim prayer, the order given by the sample court, they may proceed and they may say that the award is passed. Malad, on 3 legal.
But
grounds-
before the court, we'll see.
Now, on 3 important legal grounds, the entire question
3 important legal grounds ಗೆ objections ಬೇಕಲ್ಲ.
ಬೇಕಾಗುತ್ತೆ ಆದ್ರೆ 6-8 weeks ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
8 weeks ಎಲ್ಲಿ ತಗೊಂಡಿದ್ದು?
ಹೌದು, in the month of June we have filed.
ಆಯ್ತು, ಈಗ ಆಗ್ತಾರೆ. 19th finally. Yes.
Petitioner, the judgment debtor's petition seeking for set aside of the order passed on IA2.
What is the order on IA2?
Order issue of delivery warrant against judgment debtor.
What's wrong with
kindly see
expert decree na?
expert contested
ಮತ್ತೆ?
and later on RA has been filed. RA is pending, Milad. In page number 39.
ಅಲ್ಲ, executing court and the court that passed the decree are the same?
Yes, my lord. Well,
RA
page
pendency will not come in the way.
39, my lord, page number 39 may kindly be seen, my lord. On 26, 2025, they have filed application. On that day, same day itself, the matter heard and post for orders without giving any opportunity to the judgment debtor to argue or to file objection. 39 page.
Pendency of RA will not come in the way.
Same day it has been passed, my lord.
Serve on the counsel, the decree holder.
Please.
Counsel for the petitioner to serve on the counsel representing the decree holder before the concerned court. List the matter on 6th. Warrant of any kind hanging on the head of the petitioner shall remain stayed till the next date.
Much obliged.
Yes. Rest on. Nimda. Service matter. Allah.
But appointment of court commissioner, but the advocate is appointed for
Partition law.
yes, my lord,
FDP proceedings.
yes, for
Stay
the
quoted.
purpose of division of property, my lord.
Correct. Stay quoted.
Yes, covered by
Many judgments. I have myself held so. Yes. Of course, following the earlier. List the matter on 3rd September. Interim order subsisting would continue to the next date. Next.
but, the last occasion, my lords have dispensed with the notice to respond number 3 to 46. But
ಮತ್ತೆ ಬಂದಿದ್ಯಾ ಅದು?
ಆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ
41 to 46 ಅಂತ ಇದೆ.
3 to 46.
ನೀವೇನ್ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಾ ಅದ್ರ ಪ್ರಕಾರ ಆಗಿದೆ.
Your lordship may say 3 to
ಮೇಡಮ್ ಅದು 3 to 40 ಅಷ್ಟೇ ಹೇಳಿರೋದು ನೀವು. Look at your memo.
ಆಯ್ತು ಇನ್ನೊಂದು
ಮಾಡಿ. ಕೋರ್ಟ್ ಮೇಲೆ ತಪ್ಪು ಹಾಕ್ಬೇಡಿ.
ಇಲ್ಲ ಕೋರ್ಟ್ ಮೇಲೆ ನನ್ನಂತೆ ತಪ್ಪಾಗಿರೋದು.
ಮೆಮೊ ಕೊಡಿ.
ಪ್ಲೀಸ್.
Yes. In terms of the memo, 40 to 46 also dispensed.
41 to 46.
Yes, 3rd September. Yes, next.
Petitioner.
I filed my statement of objection. If it is not listed,
Not
before
put up.
lordship, I will give a copy.
6ನೇ ತಾರೀಕು ತಗೊಳ್ಳು. List the matter on 6th in preliminary hearing. The registry is directed to put up the
Commercial court ಅಲ್ಲಿ ಇದೆ 6th one. For the, on the same
further
day.
proceedings ಮಾಡಿಲ್ಲ.
Yes.
They list the matter on 6th in preliminary hearing. The registry to put up the objection so filed by the respondent on the next date. Yes.
Much.
Interim order subsisting would continue. Yes.
For the petitioner, my lord. And the amendment, my lord, regarding the jurisdiction, my lord, of the honorable district judges over the orders of the senior civil judges, my lords, they came into effect on 19th June 2024. The appeal is filed on 13/6/2024. Interim orders are passed on 18/6/2024. And the valuation is, my lord, the specific performance, my lords. In both the cases, one is 9 crores in the first case, second is 56 lakhs. It's much more. So the learned district judge, my lord, had no jurisdiction, my lord, to entertain this, my lord.
Who's the plaintiff?
The plaintiffs, my lords, the agreement
Fine.
holders, my lord, please.
You are judgment debtor.
No, plaintiffs, my lord, we have moved for specific performance, my lord.
Moved for specific.
Please, my lords. And injunction order is passed. After hearing, that injunction was challenged before the district judge, which is impermissible, my lords. Only MFA could have been entertained before this on court, my lords. Please.
MA ಬರಲ್ಲ.
ಬರೋದಿಲ್ಲ ಯಾಕಂದ್ರೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಆನಂತರ ಬಂದಿದೆ, that validity is there, my lord. In question, there is another aspect.
But the learned senior counsel, PP Hegde, appearing for the petitioner. Petitioner to serve on the counsel representing, I'll represent ಮಾಡಿದ್ರ?
ಹೌದು.
Representing the respondent before the concerned court/S, so and so. Till such time, further proceedings before the, list the matter on 29th August. Till such time, further proceedings before the first appellate court shall remain stayed.
Please, most good.
Both matters? Next
Both
to them,
same, my lord.
Same.
Same.
103, 104.
Grateful.
Yes. Do the remote ಬಂದಿದೆ madam?
In this case, a suit was filed during COVID period for recovery of money, and my lord, they obtained an ex parte decree, and my lord, execution proceedings were filed, and my lord, in the execution proceedings, Dashma kindly take my lord page 81, my lord,
ಎಷ್ಟು ಡಿಗ್ರಿ?
decree for 23 lakhs.
ಈಗೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಿ?
They amended the attachment order. They filed application directly under section 64. No such application filed under section 54, attachment of the property. The procedure prescribed
serve on
under
the
section
respondent.
54.
Counsel for the petitioner to serve on the counsel representing the decree holder before the concerned court. List the matter on 13th in preliminary hearing. Till such time, proceedings before the executing court shall remain state.
Much.
Next. What urgency in this?
My lord, the matter before the trial court is posted on first, my lord. 1st of August. Here, my lord,
POCSO matter.
Yeah, POCSO matter, your lordship.
What's the age of the victim?
Say victims, my lord, below 18 years, your lordship. Now, at that time, my lord, it may be.
Why 311 application is filed?
Yes, 311/91 application was filed, seeking to produce 2 letters, my lord, which were issued by accused number 1. In favor.
Issued by
accused number 1.
Oh, she's supporting accused number 1.
No, my lord, it is.
State has
My lord,
filed a
is-
recalling application.
State has filed.
State has filed. Now
Tell
we
it
are-
first.
We are on behalf of victim, my lord.
Hmm.
Not for accused, on behalf of victim, we have filed this petition. My lord, they should have filed, my lord, a petition challenging the order.
It should have been allowed. What's the age of the victim now?
Now, my lord,
Less than 18, but how much?
Less than 18, my lord, it is 17 and half, my lord. Both are 17 and
We'll allow it, madam. The petitioner, victim in both, ಎರಡು ಕೇಸ್ ಇದೆಯಾ?
For your case,
In same relief?
same relief, same similar application, same
The
document.
petition, both these, will tag it and then
Yes, your lord.
tag ಮಾಡ್ಬಿಡಿ. Both these petitions,
Notice to other
Accused also, my lord.
not necessary. ಯಾವ್ದಿದು? ಚಿತ್ರದುರ್ಗದ?
Yes, your lord. That's the reason, my lord, it has come before your lordship, because
Oh, that is
previously.
why.
your lordship
Otherwise,
has
why
dealt-
did-
Yes. Previously, your lordship has dealt this.
Correct. Oh, who is the,
My lord, here, PW 14, my lord, is a prosecution witness.
now no necessity to hear the other side?
Maybe, my lord.
If you want me to hear,
They
then
have
I will.
challenged, my lord, they have filed objection also in the
trial court that filed objections.
They have
and-
filed
Correct.
objection.
If they have to be heard, we will state and you serve on them, we'll take it Friday, on Friday.
Please,
Heard the learned,
till then not to.
correct, yes. Heard the learned senior counsel Hasmat Pasha appearing for the petitioner. The petitioner, the victim, supported by the state, files application seeking recall of the victim for further.
The state
For
itself
PW
had filed, my lord,
Only
not the
state
victim.
had filed.
Oh, state has filed.
Application was filed by
The
prosecution.
state files an application, the prosecution files an application before the concerned court in special case 182 of 2022 seeking recall of the victim for further cross-examination.
Call of PW 14, you know.
My lord, to produce, kindly, my lord, at page 42, my lord, application.
What is the order, sir? 2:30 move ಮಾಡಿದ್ರೆ ಓದಕ್ಕಾಗ ಇದೇ ಪ್ರಾಬ್ಲಮ್.
Yes, yes. My lord, page 42 is the application, your lordship.
Correct.
My lord, it was filed, my lord, to produce 2 documents, 2 letters,
sorry.
and also
File-
to recall PW 14.
File ಏನ್ ಹೇಳಿದೆ ಮೇಡಮ್? Files application under section 311 and 91 of the CRPC seeking production of 2 documents which is said to be in favor of accused number 1.
Issued by
Issue-
accused
issued
number 1 in
by-
favor
issue-
of PW 14.
Issued by accused number 1 in favor of PW 14. Therefore, PW 14 was sought to be further cross-examined in an application under section 311 of the CRPC. The applications come to be rejected, the rejection of which has driven the petitioner to the victim before this court. The respondent is said to have filed objections and contested the matter before the concerned court. In that light, the respondent will have to be heard in the matter. next date ನಾಳೆ ಇದೆಯಾ?
First, your lordship.
1st of August.
The further proceedings before the concerned court, the concerned court shall on the learned counsel, senior counsel, parties would further submit that the next date of listing before the concerned court is on August the 1st, 2025. The concerned court shall defer its proceedings till the next date. List the matter on Tuesday.
Please.
Petitioner to serve on the counsel for the respondent. Which respondent?
Respond number
Two.
2 to 4, your lordship.
Respondents 2 to 4 before the concerned court and file an acknowledgement of such service by the 1st of August. Yes. Next.
Hand delivery.
And first ತಾನೇ ಇರೋದು ನಾಳೆ ಬರುತ್ತೆ. Yes.
Both, my lord, both same order.
Both same order, same order. I have tagged the two.
Yes. SC numbers are different.
SC numbers are different, your lordship.
Madam?
Both
SC
special
numbers are
cases,
different.
numbers are different.
Madam ಅದು ನೋಡ್ಕೊಳ್ಳಿ. SC numbers.
181, 182, your lordship, numbers.
ಅಷ್ಟೇ ಅಲ್ಲೇ ಇರುತ್ತೆ.
Yes, yes.
Yes.
Hearing for the petitioner.
The list. ನಿಮ್ದು POCSO victim ಅಂತ that connected. Sorry. Yes, yes.
My lord, appearing for the petitioner bank, my lord. The petitioner branch manager is a garnishee in an execution matter, my lord. And the executing court had issued a garnishee order to deposit a certain amount belonging to the judgment debtor, who's respondent number 2, my lord. And at that point of time, there was already an injunction order from another court asking the bank not to disperse the amount. And that injunction order was binding on the petitioner because petitioner was a party, arrayed as a party. So, my lord, at that point of time, an explanation was provided to the executing court, my lord. And a memo was filed that there is an injunction order and therefore we cannot comply with the garnishee order. Now, subsequently, during the pendency of the matter, my lord, the injunction matter where the garnishee was the party was transferred to a commercial court. And so therefore it became a court of a higher grade. And so the second additional civil court said it cannot call for the the amount which has been deposited in the other court, my lord. And an order was passed, my lord, at page number 153, my lord. Specifically at 153.
Heard the learned counsel appearing for the petitioner. The petitioner is the manager of Union Bank of India, the garnishee. The garnishee order is passed against the petitioner. The learned counsel for the petitioner takes this court to the documents appended to the petition to demonstrate that prior to the impugned order, an order of injunction was operating against the petitioner in which he was a defendant. And therefore, the order that was in the subject proceeding could not be complied with. In that light, the order that is now against the petitioner is required to be stayed till the next date of hearing. There shall be an interim order of stay as prayed for till the next date of hearing. Petitioner is directed to serve on the counsel who represents the respondent in the subject proceedings and file an acknowledgement of such service by Monday, 4th August. List the matter on 29th August.
Lord, I kindly have it on the 29th. There's a personal inconvenience, my lord.
1st August.
No. After that, my lord.
29th. Then 29th August, madam. We'll take it on 3rd September.
Please, my lord. Hand delivery because the matter is tomorrow,
List on
my lord.
September the 3rd, 2025. Hand delivery yake?
Lord, the matter is tomorrow, my lord.
Tomorrow. Vijay.
Grateful, my lord.
Yes.
That's for the petitioner, my lords. Suit is one for declaration. That suit, my lords, there are 4 defendants. My lords, if my lords may kindly peruse the order sheet, my lords. It's at ink page number 26 to 26, my lords. Steps were taken, my lords, on 16/3/2015. Thereafter, my lords, we furnished a paper draft on 30/3/2015. My lords, unfortunately, on 34/2015, we could not be present to furnish.
What is the order, sir?
My lords, the order is this, my lords, that I file an application to restore the dismiss for non-prosecution in respect of defendant number 1, 2, 3. That is rejected on the count that we have not explained the delay. In the affidavit, we have explained the delay that plaintiff number 1 is the mother. She was handling all the affairs, my lords.
Again, next date ಏನು?
ಇವಾಗ ನಾಳೆ ಇದೆ on 7 Rule 11D ಮೇಲೆ orders ಇಟ್ಕೊಂಡಿದ್ದಾರೆ.
Defendant number 4, what he does is that on the strength of the order of dismissal, he files an application stating under 7 Rule 11, seeking for rejection of the plaint.
List the matter on Monday, Wednesday 6th in preliminary hearing. Further proceedings before the concerned court shall remain stayed till the next date.
May I seek for a hand delivery?
Petitioner to serve on the counsel representing the respondents before the concerned court forthwith.
May I seek
ನಾಳೆನೆ
for a-
ಸರ್ವ್ ಮಾಡಿ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಡ್ತೇನೆ. ನಾಳೆ ಸರ್ವ್ ಮಾಡಿ.
For rejectment, my lord.
Correct.
Need to vacate, some reasonable time is granted.
Your Lordship, reasonable time is already given. After the judgment, it's been 4 months. And he's been squatting over the property since 2022. And I've been trying to eject him since 2022.
He's running jewelry shop.
Jewelry shop. You want jewels or
Landlord-tenant relationship.
you want jewels or time?
Even in the written statement, all he said that he requires some time.
Hmm.
And after that, it's been more than a year. And after judgment, it's been more than 4 months.
6 months.
Your Lordship, 6 months will be, I'll be put to hardship, Your Lordship. I've been trying to vacate him since 2022. In fact, I've even given up mean profit saying that
Only
at
6
least
months,
let
but-
him vacate it.
Moreover, we're ready to pay the rents, whatever the arrears of rent is there.
Arrears
He has to.
Well, I'm ready to pay. ಅಲ್ಲ, ಅವರೇ reject
Around
ಮಾಡಿದ್ದಾರೆ, ಅವರೇ ನಮ್ಗೆ
1
ವಾಪಸ್
lakh
ಕಳಿಸಿದ್ದಾರೆ.
68,000 is pending,
ನಾವು
Your Lordship.
ಕಳಿಸಿದ್ವು, ಅವರೇ ವಾಪಸ್ ಕಳಿಸಿದ್ದಾರೆ ನಮ್ಗೆ ರೆಂಟ್. Ready to
Rent
pay.
ವಾಪಸ್
Deposit
ಕಳಿಸಿ.
ಮಾಡ್ಬೋದಿತ್ತು, ಅದನ್ನು ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, ಅವ್ರು
ಅವ್ರ
ನಮ್ಗೆ
bona fides
ಕಳಿಸಿದ್ದಾರೆ, ಏನ್
ತೋರ್ಸಕ್ಕೆ.
ಮಾಡೋದು?
That is
ಆಮೇಲೆ
a
ಅವ್ರ
different issue.
ಕೇಸ್ ವೀಕ್ ಆಗ್ಬಾರ್ದು.
In fact, I've
We are
even
ready to
given
pay the
up mean profit so that at least let him vacate. From 2020-22, I've been trying to vacate him.
Yes.
6 months.
6,000 is the rent, Your Lordship.
ಅಲ್ಲ, ಕೊಡ್ತೇವೆ, ನಾಳೆ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೇವೆ.
ನಾಳೆ
That is not the question.
Within 2 days, we are ready to deposit the entire arrears of rent.
And file an affidavit.
Your Lordship.
Just 5.5 months ಸಾಕ?
Your Lordship. It's been more than 4 months since the judgment itself. And in fact, when the bailiff goes, he in fact, I have a undertaking where he undertakes saying that in 2 days I will vacate.
ಡೆಲಿವರಿ ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಬಂದಾಗ
ಮತ್ತೆ ವಾರಂಟ್ ಹ್ಯಾಂಗ್ ಆದಾಗ ಅದೇ 2 days ಬರೋದು.
Bailiff al hogaga, he shut the shop. And after that, he comes running to me saying that I'll vacate it tomorrow. And then he says, don't press the execution.
All right.
6 months
Yes. No. 3 months ಸಾಕು. bailiff 2 days ಅಂತ ಹೇಳಿದ್ದೀರಾ?
5 months. 5 months. We are ready to pay the entire arrears.
You have to pay, there's no choice.
Within 2 days ಎಲ್ಲ ಪೇ ಮಾಡ್ತೀವಿ, ತೊಂದ್ರೆ ಇಲ್ಲ.
ನೀವು ಪೇ ಮಾಡಿ affidavit ಹಾಕಿ. ಅದೇನು?
Just that undertaking, Your Lordship. In 2 days,
ನಾವೇ
he
ಹೇಳ್ತಾ
said
ಇದೀವಿ,
that he's
undertake
going.
ಮಾಡ್ಕೊಂಡು, ನಾವೇ
In
ಇಲ್ಲ
fact,
ಅಂತ
even
ಹೇಳ್ತಾ
this
ಇಲ್ಲ.
morning, my instructions were that even this morning, because execution was listed today. And even this morning, he was in touch with me saying that I'm going to vacate it. And then he moves for
ಹೇಳಿದ್ದು
2:30
6
hearing CRP petition.
ಇಂಟಿಮೇಷನ್
This is the
ಮಾಡಿ ಮೂವ್
conduct.
ಮಾಡಿದ್ದಾರೆ, ಇಂಟಿಮೇಷನ್ ಕೊಟ್ಟೆ ಮೂವ್ ಮಾಡಿದ್ದಾನೆ. 6 months ಅಲ್ಲಿ ಖಾಲಿ ಮಾಡ್ತೀನಿ, ನಾವೇ ಹೇಳ್ತಾ ಇದ್ದೀವಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. 4 months.
Half of that.
4 months. 4 months ಅಂದ್ರೆ ಸ್ವಲ್ಪ.
Half of that.
4 months.
2
Half
months
of
is
that.
the order.
ನೀವು ಎಷ್ಟು ಹೇಳ್ತೀರಾ ಅದು half of that.
ನಾವು ಜಾಸ್ತಿ ಹೇಳಿ.
ಅದಕ್ಕೆ 3 months ಇಟ್ಕೊಳ್ಳಿ, ಇಲ್ಲ ಅಂದ್ರೆ 3 months half of that ಆಗುತ್ತೆ. 3 months file an affidavit on Friday, we'll close it. We'll close all the proceedings.
Executing court.
Executing court ಎಲ್ಲ close. We'll direct drawing up of a decree in that kind. 3 months.
Tomorrow.
ಮತ್ತೆ ಅಲ್ಲಿ ಹೋಗೋದು, ಅಲ್ಲಿಂದ ಒಂದೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಇಲ್ಲಿ ಬರೋದು ಅದೆಲ್ಲ ಇಲ್ಲ.
Pay an affidavit here.
Yes. 3
Payment
months.
also, Your Lordship. Payment also. If
ಅಲ್ಲ, ಬಿಡಿ ತರ್ತೇವೆ, ತೊಂದ್ರೆ ಇಲ್ಲ.
That's no option.
Great.
Just
Tomorrow.
3 years ಅಷ್ಟೇ. 3 months, sorry. 3 months. Yes.
To file an affidavit tomorrow.
Day after tomorrow. Serve a advance copy tomorrow.
Please.
We'll close it on Friday.
Grateful.
Grateful.
Admission. ಕರೆದ್ಬಿಡಿ admission. Not 6. CH mode ಅಂತ ಇದೆ. ದೇವರಾಜ್. ಎಂಟ್ರಿ ಮಾಡಿದೆ ನೋಡಿ.
498 and 306.
498 306. Husband.
306. Please, Your Lordship. Husband.
Settlement. ಯಾರು? nobody is present. We'll post it next Friday. ಅಲ್ಲ, ನೀವು ಯಾವತ್ತು ಫ್ರೀ ಇರ್ತೀರಾ?
Any Monday, Tuesday, Wednesday.
Tuesday,
or
we'll post it on Tuesday. List the matter on Tuesday at 2:30 PM. 107.
This is the revision after conversion as MSA. Earlier it was filed, MSA was filed. A suit for
My lords, I
partition.
appeal for respond. My lords, the suit is of the year 2005, my lords. He files in RA. In RA is being dismissed for non-prosecution. Again, a mispetition is filed. In that 8,000 rupees cost is there, and they have very specific directions to appear before the court. He does not appear. Subsequently, after 5
Miscellaneous
years.
appeal ಯಾವಾಗ file ಮಾಡಿದ್ರಿ?
Yes, yes. Final order.
Suit is 2007.
Yes.
2007
ಇಲ್ಲ,
miscellaneous.
miscellaneous petition is 2007.
Yes, my lords. Yes. My only prayer is the RA may be heard on merits. I cost
Acts
is
are like
paid.
this, my lords.
8,000
RA is rejected for what?
for non-prosecution. It was not heard on merits. My only submission is.
Consider
One second, my lords, the only thing is, my lords, suit for partition filed by the first wife children against the father and the second wife children.
ಇವ್ರು ಯಾರು?
Second wife.
ಅದೇ problem.
And my lords, they have already alienated the property. Our share almost alienate to ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. Kindly see the judgment which they have produced, my lords.
What is the date of the decree?
2005, my lords.
Yes.
RA filed on?
2005, my lords. RA was
Ive-
filed in time. Subsequently, it was dismissed from non-prosecution. Again, 2007, they filed a miscellaneous. And, my lords, they don't.
2007 miscellaneous ಏನಾಯ್ತು?
Restored my lord, on payment of cost. 8,000 cost was paid. They have filed the signature, they have appended the signature for receiving the cost. But the court was not convinced. So even on the payment of cost, the court dismissed that. So on that I filed MSA here. On the office, the direction of this court, it was converted to CRP. Now the CRP before this.
No, my lords, it is like this. It was allowed on 19/12/2018. My lords, kindly take page number 34 of the compilation, my lords. The order, the petition filed by the petitioner under order 41/19 of CPC is by allowed on the cost of rupees 8,000 payable to the consenting respondents. The respondent shall pay the cost to the consenting respondent either by depositing before this court or by an actual payment to the said respondent a sum of rupees 8,000 as cost on behalf before the date mentioned below. Payment of cost shall be precondition for the further proceedings in furtherance of this order.
Cost payment
Specific after on 18/3 they make the payment. They were supposed to appear before the court on 5/2/2019. No,
But
not on the.
RA was preferred within time.
RA was preferred within time, but dismissed for miscellaneous again.
No, RA was dismissed for non-prosecution when?
Yes.
My lords, 14/8/2007, my lords.
Miscellaneous was preferred when?
2007. Yes.
Miscellaneous
2011
2007.
miscellaneous 17 of 2019 ಅಂತ ಇದೆ.
38 MA.
MA, my lords.
MA. Says appeal.
That is against the dismissal.
Yes, my lords.
Yes. MA 17.
Lords, there is nothing for their challenge now. Now the final decree proceedings already there. It has been drawn. Now already they have alienated their share property. The rest of the whatever the property is there, it has to come to the first wife children itself, because both father and children have alienated it.
Your share na
alienate ಮಾಡಿದ್ದಾರೆ, judgment ಅಲ್ಲಿ ಇದೆ. Just pass the judgment.
Short date may be given. I'm not shying away or delaying the proceedings.
Kindly see the highlighted part.
Only submission is an opportunity we have granted with time frame. I'm not delaying the proceedings or denying the whatever results.
After getting your share and alienating that share also, what is that you want to do in appeal? ಅದಕ್ಕೆ interest ಇಲ್ಲ.
The submission may be that the appeal may be heard at least one day, within 1 day it may be disposed of. With time frame.
ಅಷ್ಟೇ.
Allah, time frame, Melody, it's only an appeal. And he is already on record.
Appeal 1 day dispose ಮಾಡಿ ನಾನು direction ಕೊಟ್ಟಲ್ಲ.
Only that I'm not, for no reason I'm
ask
delaying.
for tenable directions.
I'm only requesting this court to afford an approach. That's because cost was paid and it was already. So my only submission is that
We'll hear it.
maybe heard on.
We'll
the
hear
RA,
it.
the RA may be heard on.
We'll hear this.
Yes.
Yes. List
But,
on 29th.
Because the FDP request to be considered.
List on 29th.
Great.
Please, madam.
List on 29th.
But the 29th is the FDP. Before that, it's a date is
No
fixed.
problems. Yes.
The date is fixed, madam. Therefore,
Parval.
maybe earlier, madam. I'm
No,
not.
sir. 29th. Yes.
Earlier. So
29th.
it is on 22nd of August.
29th, sir. Yes.
Highly obliged.
What on it agenda?
I appear for government.
Partnership firm, my
711.
lord. Yes, my lord. Partnership firm, my lord. There are some disputes, my lord. They filed a suit, my lord, few partners, my lord. There's an arbitration clause in the partnership deed, my lord, on that too.
Place the matter on 3rd September. 3rd September.
My lord, they are taking the undue advantage of the interim order of this court.
We'll admit
Because
the matter then. Yes.
No, they are not cooperating in paying, signing the check to pay
They
the
ಆದ್ಮೇಲೆ ಏನು sir?
GST.
List the matter on 3rd September. Interim order subsisting will continue to the next date of hearing. Big group ಇರೋದೆಲ್ಲ tax matter. Just take that 4 o'clock matter on dictation and stuff. 4:30 the. Tax, 3:30 ಇದೆಯಾ? ಯಾವುದು?
183. ನಾನು 183.5 ಅಲ್ಲಿ ನಾನು. In fact, unrelated matter, it was tagged on the first day itself. On 5/7/2024.
GM DRT, why is it here?
It is part-heard matter.
Parted, we'll release
So
it.
ಬೇರೆ matter ಸ್ವಾಮಿ, ಬೇರೆದು
We'll
parted
release it
ಆಗಿತ್ತು.
from parted.
ನಮ್ದು very first day it has been tagged.
Release these matters from the status of being part-heard. Post the matter before the bench having roster.
Serial number
Interim
183.
order, if any, would continue till the next date of
Lord,
hearing.
in this batch, my lord, in this batch 183.
What is this batch ಇದೆಯಲ್ಲ? What is
Lord,
question?
your lordships have heard this substantially, my lord. It was a limited issue. My lord, whether, my lord, the DRT could have refused to receive the written statement in an OA when, my lord, the exclusion of limitation order of the Honorable Supreme Court was in operation. That's the question in mind. And, my lord, there are various other aspects, my lord, including with regard to the contract. Your
Post
lordships
the
have
matter
heard it, my
before
lord.
the bench having roster. DRT, ಬೇಡ.
My lords, the interim orders may be
Interim orders
extended.
will continue.
My lords, may I then make one request? Other connected matters.
ಅಲ್ಲೇ ಕೇಳಿ. Yes.
Great.
My lords.
182 ಏನು?
This is a matter pertaining to the pollution control board where CFO was not issued. So
There's
the
an
PCR
interim order.
Yes, Your
I think the
Lordship.
petitioner has.
Next Friday.
Your Lordship, after 10th only.
10th, 12th.
That's okay.
Interim order subsisting will continue to the next date of hearing.
Careful.
Now orders at 4:30. Yes, Tholit.
Yes.
This to dictate.
Yes, Madam. I just have 5 minutes of submissions to make, not on the previous date.
Yes, Sanusha madam.
I have no submissions to it.
5 minutes submission.
Goods memo. This good. But there's a memo that I'm just handing over.
Copy.
Giving it to them.
Then we will have to hear the other side also.
These are just written submissions, Madam, and some list of
Written
authorities.
submissions.
Yes, Madam. I've handed over some written submissions as well. Sorry, list of authorities.
That's the court copy.
Not. Memo, my memo. Please have the memo, Lord. At page 18, there's a chart that I have provided.
Judgment.
No, not list of authorities.
Falsehood matrix.
Falsehood matrix. Not on the previous date. I'd shown your lordships how there was a false pretext of having procured documents through an RTI. 10 documents were sought to be produced in evidence. In a suit of 2004, which was the documents which were publicly available from 2007, when the matter was put for arguments, they have now, through a false pretext, sought to produce certain documents. Lord, just please see in that chart, Exhibit P5 was the principal reason as to why they wanted to produce certain documents, because in their affidavit they had said the genuineness of Exhibit P5 was called in question during the cross-examination. So in order to prove the genuineness of Exhibit P5, we want to produce certain documents. Lord, I have produced a comparative chart. Last page of that memo, Lord. Just please see this.
Yes.
Last page, your lordships will have a juxtaposition of 2 survey sketches. Exhibit P5, Lord, which was marked in evidence. your lordships will find on the left-hand side. Now, the right-hand side, what your lordships are seeing is document number 10 appended to IA number 33. Now, your lordships will see on a quick comparison, both these sketches are not the same at all. Lord, my client has applied for RTI of that entire survey file.
It's
And
not there, and the last time you told. No document of that kind is available.
There are two separate things, Lord. One is the RTI which they had applied for procuring documents concerning that 2007 survey record. In that RTI, Lord, for which they applied to secure document, my client had gone and applied for RTI to see what was the correspondence, what were the documents given. There, we had correspondence to show that nothing was given to them. There's a separate RTI that we filed for the 2007 record, in which we found this exhibit P5, Lord, does not even exist, form part of that file at all. Now, exhibit P5, Lord, is the entire basis on which they amend their 2004 suit, which was a bare injunction suit, to a declaratory suit. In 2009, that amendment application was filed. They convert that suit to a declaratory suit, then they seek several amendments, everything, which is not part of the file at all. Another false suit. Now, please come back to the table, Lord. Your lordships will see in the chart, they assert that they got their certified copies on 11/6. I just want to explain to your chart and leave it to your lordship.
Yes.
Now, please see on column number 2 is what have they asserted in their affidavit. Column number 3 is how their own claims in their affidavit stand contradicted. Lord, they say that they discovered for the first time these 5 documents through an RTI in June 2025. See row number 3. Certified copies of these very documents were part of a writ petition filed in the year 2024. I have given your lordships document references as well.
Yes.
They say that in spite of due diligence, they could not have produced these earlier. This was with them since 2007. They had the original record, they had the certified copies, they had already produced it. And now they have set up this false pretext. There's one leading judgment that I want to show your lordships, and with that I'll close.
No, but with all this production and the copy given now, they will, we have to give them.
Yes, let them have a chance. Let them explain.
Because if I have to incorporate all this and consider in the order, they should have theirs.
I have no difficulty. They should be given full opportunity to explain. Even on the last time they had the opportunity, they in fact said we don't want to go into these long winding arguments. But I have to show when you stand.
No, because this is there. Yes,
I have no difficulty.
My lord, I want to submit one submission, my lord.
Yes.
Lord, 2023, this suit has been restored by a coordinate bench. 10 years it was dismissed for non-prosecution in 2013 for the second time. 2023 it was restored with a specific direction after imposing costs that the suit will be disposed of in 1 year with cooperation of the plaintiff. The plaintiff files 11 applications at different stages. I've given your lordship a chart of the number of applications filed in the last 1 year only to drag on this litigation. Lord, they drag on this litigation when it is at the stage of arguments to reopen the evidence. Your lordships ask, what are you suggesting when they come out with this falsehood? One is not clearly it's abuse of process. I used wrongly, not serious costs. I have judgments of Justice Arvind Kumar and several other judgments of Justice R.V. Ravindran as well. Deterrent costs must be imposed for such conduct. And your lordships recently in the land acquisition matter, where lordships imposed 10 lakh costs in para 25, have described what these new creed of litigants I produced that also in my list of operators. This litigant is not just belonging to that new creed of litigants who's taking the courts for life. He's a seasoned player in that new breed of litigants. Now, my lord, please see the list of authorities. There's one judgment I want to show your lordships.
We'll look into it.
Just one judgment, lord, one paragraph.
So many.
Which is the leading judgment. No, I'll just read one. Justice Ravindran's judgment, which is the Bible on Order 18, Rule 17. Page 92 is where it begins.
The apex court.
19 at
Apex
page
court.
Apex court.
Then say apex court. Why name of the judge?
In fact, sometimes the
the
author of the judgment will have stronger persuasive value. Of course, it's binding because it's
not in this court.
Not in this court.
I told him that.
Yes. Para 18, para 19 at page 102. 102. We may add para 18 at page 102. But this is the Bible on Order 18, Rule 17. This application for recall, reopening, and production has to be in conformity with this law.
Strictly construed.
Yes. We may add a word of caution. Your lordships are on para 19. No?
Yes.
We may add a word of caution. The power under 151 or Order 18, Rule 17 is not intended to be used routinely merely for the asking. If so used, it will defeat the very purpose of various amendments to the code to expedite trials. where the application is found to be bona fide and where the additional evidence, oral or documentary, will assist the court to clarify the evidence on the issues and will assist in rendering justice, and the court is satisfied that non-production earlier was for valid and sufficient reasons, the court may exercise its discretion to recall the witness or permit the fresh evidence. But if it does so, it should ensure that the process does not become a protracting tactic. The court should firstly award appropriate cost to the other party to compensate for the delay. Secondly, the court should take up and complete the case within a fixed time schedule so that the delay is avoided. Thirdly, if the application is found to be mischievous or frivolous or to cover up negligence or lacunae, it should be rejected with heavy costs. If the application is allowed and the evidence is permitted and ultimately the court finds that the evidence was not genuine or relevant and did not warrant the reopening of the case recalling the witnesses, it can be made a ground for awarding exemplary costs apart from ordering prosecution if it involves fabrication of evidence. If the party had an opportunity to produce such evidence earlier but did not do so, or if the evidence already led is clear and ambiguous, or if it comes to the conclusion that the object of the application is merely to protract the proceedings, the court should reject the application. Now, this is the law that your lordship will consider in deciding whether their application is bona fide, should be considered not for reopening of the evidence. This, Lord, I told your lordships, 2007 is a public record which was always available to them. They first entered the box in 2013. That was the first available opportunity when they could have entered the box and presented that evidence. In 23, when it was restored, they had an opportunity. Even then, they don't do it. 24, Lord, they file an application to summon the tehsildar to prove the genuineness of Exhibit P5. The application is dismissed. They come to this court. This court allows their application to summon the tehsildar and prove the genuineness of Exhibit P5. Once the tehsildar goes into the box, they abandon the witness. So the tehsildar who was summoned for proving the genuineness of Exhibit P5, once dismissed, this court allows it, goes back there. There the application, he comes there and they give up the witness without examining him. And now when it is arguments, they want to recall the stage, reopen evidence and produce documents which relate to 2007. Three consequences, Lord, in my judgments, Lord. One is this amounts to abuse of process. Two, Lord, it amounts to clear perjury for having fabricated falsely, for having pleaded falsely on affidavit. I've given 6 different chart, Lord, to show the extent of falsehood with which they've come before this honorable court. And therefore, Lord, if on the basis of false pleading, if the court is deceived into allowing your application, it also amounts to criminal contempt. For that also I've given your
Criminal contempt.
Yes, the judgment, I've given it.
Yes, Anush.
My lords, in the last day they filed a memo saying that nange documents sikkilant. I filed my objection to that memo, my lords. That has been
Documents sikkilla anta yaru hakid?
a memo was filed by the petitioner saying the documents was not given to me by the RTA authorities at all, my lords.
Huh.
So I have filed my objection to that memo, my lords. With respect to all the submission
not
that has
been served with that.
my lords, with the proof of service, it has been filed before your lordships. Email
Electronic service, huh?
Please, my lords.
All right.
I have not seen it, Lord. I'll see it and reply.
My lord,
Now you reply to all this. I'll give a date. When do you want?
Friday, my lords.
All right, Friday. We'll sit on Friday at the same time.
Please, my lords.
Heard the learned counsel, Angat Kamath appearing for the petitioner, and Anusha, your full name?
Anusha B. Reddy, my lord.
Anusha B. Oh, it's here. Anusha B. Reddy appearing for the respondent. To hear the respondent's counsel on the
Memo.
On the memo so filed appending several documents. List the matter on Friday at 4:30 p.m. Yes. Now one passover ಆಗಿತ್ತಲ್ಲ madam? ಅಲ್ಲ ಫಸ್ಟ್ ಒಂದು ನಾಗಾನಂದ್ ಸರ್ದು ಯಾವ್ದಾಯ್ತಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಯಾವ್ದದು ಅಲ್ಲ ಅದೇ ಫಸ್ಟ್ ಅಲ್ವಾ that being spoken
Kind intelligence.
One ನಿಮಿಷ
63.
My lords, we have served the advancement application on B6, my lord, by way of electronic service.
electronic service
Sorry, my lords.
ಅಲ್ಲಿ ಬ್ಲೂ ಟಿಕ್ ಬರಲ್ಲ.
No, my lords, they have acknowledged and they came before the honorable trial court, my lords.
Oh, after receipt of that is it?
After the receipt of that.
All right, respondent ಇಲ್ಲ.
My lords, interim order may be extended.
Yes, we'll list it on Friday. Friday at the same stage, interim order subsisting shall continue to the next. No, that 3 weeks ಮಾತ್ರ
This
ಐತಲ್ಲ.
is already expired, my lord, on 24th.
No, the learned counsel for the petitioner has moved. Yes.
My lords, it cannot be extended, my
No,
lord.
madam, the service of notice, she has said that
On D6, we have served.
it
my
is
lord.
by,
I am-
how did you go before the court?
My lords, I'll
How
explain.
did you go before the court?
I'll explain, my lords.
Ah.
My lords, on 20th, so the next date, it was on 30th, my lords. 20, after these orders were passed, 30th, 8 was August. They've gone and
Advanced it.
it on 22nd, my lords.
All right.
Subsequently also, they don't inform me that they have advanced the matter.
Why did you go there?
My lords, I didn't know what happened, my lords, on that day, on 28th. From 22nd, it goes to 28th, my lords. On 28th, it so happens, we've taken a Passover. What happens is we were there in that court hall and we asked for a Passover to file my wakalat because I was not aware of this matter being filed on that date. My lords, so the manner in which they have gone ahead, they've not served it upon me. I appear for D10, my lords, because I was directed
You
to go.
you have served on D6.
D6, my lords, and on the
Why
same
not to others?
D10, we have not served, my lord. Apologies to that, my lord.
lord.
But they were aware, my lord. They were before the honorable
Apologies,
trial
madam. So interim order will not be
And
extended.
the
My lords,
manner in
I
which they have
beg your
gone, my
lordship.
lords, second, your lordships passes an order.
Advancement
23rd
ಮಾಡಬೇಕಾದ್ರೆ you should serve on the other side. Basic practice.
My
If you
lord,
if you don't serve on the other side and they are not aware, you serve on D6 and order is passed against D10, no?
My lords, they were very much present, my lord. In the
They
last
may
hearing,
be present on their own, but have you done your job? That's what I asked.
my lords,
Sadanand.
22nd, I
Then-
was nowhere present, also recorded, my lords. And to bring your lordships notice, second, your
And then,
lordships
my lord,
passes an order.
now they come and file Order 7, Rule 11 application, my lord. Next stage is for objections to file from my side, my lord.
Order 7 rule 11
Order
again.
7, Rule 11,
My lords, my written statement also has to be filed on 1/8.
I'll take it on Friday.
My lord, still then,
My
my
lord,
lord.
No, no,
interim
what's the
order-
next date?
1/8, my lord.
1/8.
They'll take advantage of this,
My lords, how, my lords, the
They
manner
will
in which,
take advantage because you have not complied with service.
Apologies for that, my lord.
Apologies will
Till
not
then,
work, madam.
my lords,
Order may be
23rd,
extended.
if I can bring your notice, my lords, 23rd, the 3 weeks period expires, my lord. They had all this file. One day before the 3 weeks period is
Not
expiring.
one day before 3 weeks, my lord. This is a wrong submission.
My lord,
I
second,
have advanced the matter on
No, no, no.
22nd.
One day before the 3 weeks expiry, you are here is what is said.
My lords, 3 weeks.
ಪೂರ್ತಿ ಕೇಳ್ಬಿಟ್ಟು ಉತ್ತರ ಕೊಡಿ.
They go and advance the matter, my lords. They should have done it all this while no bona fides are shown. They don't serve it upon me. Morning they submit, they've served it. No acknowledgement is shown,
my
my
lord.
lords.
Senior was not knowing that I was the person who was.
My lord, that's not a ground, my lords.
It's your mistake.
Yes, my lord. I agree. I apologize for that, my lord.
We'll take it tomorrow then. Tomorrow in the second list we'll take.
Till then, tomorrow.
Till then tomorrow ಅಷ್ಟೇ.
My lords, anyways 3 weeks period lapses, my
No,
lords.
till then first ಅಲ್ವೈರದಲ್ಲಿ.
180.
Tomorrow will pass.
My lord's interim order. Till tomorrow,
Tomorrow.
my lord.
We'll take it tomorrow. Yes.
Please, my lords.
Grateful, my lords.
Yes, next. Who's for the petitioner?
It's Madam Lord,
Ah,
which has
yes,
to be
yes.
heard. No, my lord, if your lordships, I see, my lord, that every day it is, my lord,
What to do? Yes.
doesn't seem to be any respite for the court.
Respite, yes. Alright. Tomorrow we'll take it. Tomorrow it's
Afternoon,
relatively less.
I have some difficulty in post-lunch session tomorrow.
No, no, pre-lunch only we'll take it.
Maybe on Friday, my lord. Tomorrow senior is having some other matters in Dharwad.
Friday, and I'm not in town.
VC la pera ಕೇಳಿ. Yes, we'll take it tomorrow. Interim order ಇದೆಯಾ ಅಲ್ಲಿ? Continue till next week. Yes.
Petitioner. Before the respond number 8. So my name will be directed to office to show my name. I had filed the application and statement of objections also.
Registry to print the name of Badrinath R as appearing for
Respond number 8.
respond number 8 who has filed the application seeking vacation of the interim order. Next week, 6th.
Please.
Interim order subsisting would continue to the next date of hearing. Yes.
Awaits regard.
Awaits are-
The co-owners of
yes.
the property.
Yes, next. Ashana? Sixth. Wish Shanti Bhushan.
Monday, my lord.
I have no difficulty. Can come
What
up.
happened? Patients were not
Patients
examined?
went. In fact, after the patients going there, the Center for Excellence says that we are not in a position as per the rare disease policy to give you any reimbursement because cystic fibrosis comes under some group 3, which is beyond the coverage. You can only put a list, put your name in a list where we are asking for crowdfunding. So we went and gave our names in one list. That is all. So of course we can take it up on Monday. I have no
We'll
difficulty.
take it on Monday. Yes.
But the submission made by the previous council, based on which my lords in fact said that you go there. In fact, the submission was that, yes, you go there, we will give you 50 lakhs. In fact, they are not issuing it because as per the
Let
policy.
Shanti
it's-
Bhushan come
Very
because he was present on the
Yes, yes, very good.
list on heard the learned senior counsel Jaina Kothari appearing for the petitioner. List the matter on Monday. Get him on Monday.
Great.
Yes.
My lord, I am for respondent in this matter, my lord. My lord.
PWSSP.
My name was not shown. That's the reason I could not carry I am in handicap
Will
state,
violate.
my lord. Can it be?
For
had
registry to
and-
print the name of KB Monesh Kumar. Monesh Kumar, la?
Yes.
Monesh Kumar is appearing for the respondent BWSSP. Monday? Monday or
That's
Monday?
okay.
Monday, but
Monday.
it's Tuesday.
Tuesday, please, my
Yes,
lords.
Tuesday.
So grateful.
Correct. B group alva.
The lords kindly. 34 was passed over, my lords.
34 is again over. Where are you?
I'm sorry, my lords. No, 8 ಅಲ್ಲಿ ಇದೆ.
Wait. We'll talk to you at the end. Yes. 6th ಗೆ ಹಾಕಿದ್ದೀನಿ.
ಅಲ್ಲ, interim order on the extension.
ಅದಕ್ಕೆ ಇರಿ. Yes. Now all this IT, Tirumalesh sir was here. All the IT matters on the next date, Dilip, and on Thursday, whatever is in B group, we'll post it on 7th, 14th or 21st. We'll distribute it. Then interim orders wherever are they, that will extend. Don't have to worry about it. Yes. 117 ಅವರಿಗೆ ಡೇಟ್ಸ್ ಕೊಡ್ತೀನಿ ಆಮೇಲೆ 7th 14th. ಹೌದಾ ಸರಿ ಆಯ್ತು ಸರಿ. ಒಂದು ನಿಮಿಷ ಪೇಜ್ ವೈಸ್ ಕರ್.
My lords, for the respondent number 2 and 3 in this case, my lords.
Vacating stay application. List the matter on 20th. Interim order subsisting would continue to the next date of hearing. 119.
Respondent is a senior citizen and a widow. Suit is state, please.
119 ಏನಿದೆ? CRP connect ಆಗಿದೆ?
CRP
Yes, Vasant, what is this?
And review up.
ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ತಾಳೆ. List the matter on 13th in preliminary hearing. Yes, interim order subsisting will continue till the next date of hearing. Yes. 29th. Interim order continue. Interim order idea? 20 interim order ilva. Hagar 13th preliminary hearing. 122.
I prefer the petitioner, my lord.
Interim order idea?
For the respondent in this matter, my lord, last time they had undertaken to pay 6.5 lakhs, my lord. On that condition, my lord, the interim order was extended.
There is a direction from 6
Two
lakhs.
times they have sought time, my lord.
No, 35 lakhs has been paid. my
Be
lord.
cleared by then, subject to the aforesaid interim order granted earlier is extended till the next date of
What
hearing.
happens, my lord?
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
35 lakhs.
ಅಲ್ಲಲ್ಲ ಈ 675 ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
ಇವತ್ತು ಆಗಿತ್ತು ಒಂದು ಸಬ್ಮಿಷನ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಅಸ್ we are satisfied the decree. But while filing the execution petition, they calculated the interest from the date of they handed over the loan to me. In the suit, mana decreed from the date of suit 2022. 5 years.
ಅದಾದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ?
ಅದಾಗಿದ್ರೆ ಒಂದು 3 ಲಕ್ಷಕ್ಕೆ ಬರುತ್ತೆ. 30 lakhs ಆದ್ರೆ
ಅಲ್ಲ 675 ಬದಲು 3 lakhs ಆಗುತ್ತಾ?
ಹೌದು ನಮ್ಮ ಪ್ರಕಾರ.
ಈಗ ಯಾವಾಗ 3 lakhs ಕೊಡ್ತೀರಾ?
ಮಂತ್
ಮಂತ್ ಯಾವ ಮಂತ್ ಇಲ್ಲ. ಎಸ್.
What happens? ಅಲ್ಲ ಏನಾಗಿದೆ ಅಡ್ವಾನ್ಸ್ ತಗೊಂಡಿದ್ವಿ ಅದಕ್ಕೆ.
I'll list the matter on 13th. In the event the petitioner would not pay 3 lakhs by the said date to the respondent, the interim order would stand automatically vacated. In ಮೂರು ಮುಕ್ಕಾಲು ಲಕ್ಷ ಆಮೇಲೆ ನೋಡೋಣ.
Please.
Yes, next.
Well calculated memo ಮೇಲೆ according to
124 is ಅರ್ಜನ್ ಆಗಿಲ್ವಾ? interim order ಇರುತ್ತೆ ಇದರಲ್ಲಿ ಇಲ್ವಾ? 7th, yes. interim order ಇದೆಯಾ ನೋಡಿ? List after 2 weeks, yes. ಇದು ಟ್ಯಾಕ್ಸ್ ಕಸ್ಟಮ್ಸ್ ಆನ್ interim order ಇದೆಯಾ? ಇಲ್ವಾ? 7th not sought. List on 28th. Yes, next. ದೇವಯ್ಯ interim order ಇಲ್ಲ ಅಂದ್ರೆ 7th, ಇದ್ರೆ 28th. Same order.
29. It is a 2014 partial suit matter. Next week I request.
ಅಲ್ಲ next week, yes. List on 20th.
2014 suit matter.
20th, yes. 20th, sir, yes. Interim order will continue.
Again, for petitioner, my lords, the issue is on the preliminary issue, framing of the preliminary issue. There is an
Interim order is there?
them.
Interim order there. 2 weeks IO. Next.
Maybe kind next.
It's interim order is there, my lords.
2 weeks IO.
Extension.
Yes, next. Two weeks IO. 134 to 137 ಅಡ್ಜನ್ ಆಗಿದೆ. 138, 139.
Challenging the rejection of the
133, my lord, 133.
133 is adjourned, sir. Yes. Interim order ಇದೆಯಲ್ಲ 133.
Yes, my lord. Interim order.
Blanket ತಗೊಳ್ಳಿ. Wherever interim orders are there of GMCPC, unless vacating stay application is filed, list those matter after 2 weeks. Interim order subsisting would continue to the next date. Tax matter, wherever interim order is there, list it on 28th. Where interim orders are not there, list them on 7th.
My lord, serial number 143, my lord. My lord.
Interim order ilva?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಿದೆ ಅಂದ್ರೆ
vacating stay ಹಾಕಿದ್ದೀರಾ?
vacating stay ಅಲ್ಲ my lord, I have ಇದರಲ್ಲಿ ಪೊಸಿಷನ್ ಎಲ್ಲ ತಗೊಂಡ್ಬಿಟ್ಟು ಏಪ್ರಿಲ್ ಅಲ್ಲೇ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. They were not brought to my lord's notice and she is the old lady.
Stay ಇದೆಯಾ?
Stay ಇದೆ.
vacating stay ಹಾಕಿ.
ಅಲ್ಲ ಇದನ್ನ ಹಾಕ್ತಾ ಇದೀನಿ ಸರ್.
ಆ vacating stay ಹಾಕೋಂಗಿದ್ರೆ ಹಾಕಿ. Yes.
My lord, date my lord for
you file vacating stay and move it. Yes.
Previewing my lord.
162.
Please use. I have filed an application for vacating stay.
ಅದು post ಮಾಡ್ತೀನಿ. vacating stay applications will be listed on a particular
I
day.
request my lord, preliminary.
File a vacating stay.
I will file my lord.
Virtue of this order, he has filed application.
vacating stay ಹಾಕಿದಿರಲ್ಲ sir. We'll post it. Yes. Vacating, madam, vacating interim orders, you post them on 6th ಎಲ್ಲ.
Silver 165, my lord.
Please.
165, my lord. That is the interim order operator against the executive court order, my lord. I filed
ಆಯ್ತು.
application for
All that
vacating the interim
application
order.
ಹಾಕಿದಿರಲ್ಲ, it will be
Application is
listed on
pending, my
6th. 6th, sir. Yes.
Serial number 140.
6th, yes.
160.
160? Interim orders will continue wherever it is. Yes.
143 6, my lord, I will file my vacating
You
stay.
file vacating stay, move
Tomorrow
it
itself I file my lord, because I have brought memo my lord saying that.
vacating stay ಹಾಕ್ಬಿಟ್ಟು ಮೂವ್ ಮಾಡಿ ಸರ್.
Please.
ಗೊತ್ತಾಗ್ಲೇ ಅಲ್ವಾ ಹೇಳಿದ್ದು?
Please.
Serial number 140.
156 for petitioner, my lord.
And for the respondent, I filed objections to the main petition.
No, madam, I have told you ಅಲ್ಲ ಏನೇನ್ ಮಾಡ್ಬೇಕು ಅಂತ.
Objection is as per the vacation of the
My lord, one submission.
No problem. If that is the case, it will be posted.
Come up, the respondent notice has not been served.
separate application in ಹಾಕಿಲ್ಲ. 56.
ಅದ್ಯಾವ್ದು ಕೇಳ್ಕೊಳ್ಳಿ ಮೇಡಮ್, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ ವೇಕೇಟಿಂಗ್ ಎಂಟ್ರಿ ಮಾಡೋ ಕೇಳಿದ್ರಿ.
My lord, this is a matter of 138, my lord, that wanted to.
138.
138 proceedings ಅಲ್ಲಿ execution ಹಾಕೊಂಡು, my lord.
156 GMCPC. ಮತ್ತೆ
execution application ಮೇಲೆ ಬಂದಿರೋದು. 47 application ಹಾಕಿದ್ವಿ.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್.
And respondent
ಫೈಲ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ ವೇಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್.
My lord, 179, my lord, 179 vacating application is pending along with the.
It will come on Wednesday and ಮಧ್ಯಾಹ್ನನೇ ಹೇಳಿದೆ ನಿಮ್ಗೆ.
My lord, 155.
ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅಷ್ಟೇ. Yes.
My lord, 155.
date ಕೊಟ್ಟಿದ್ದೆ.
It will come, yes.
ಇನ್ನೊಂದು
482 ಒಂದು ಹಾಕಿದ್ವಿ. My lord may tag that number, my lord, along with this.
482 won't come before me, sir.
Like the connected matter.
Serial number 158 lordship. Settlement ಆಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ. May kindly have it on Wednesday.
ಆಗೋಗಿದೆಯಾ ಆಗ್ತಾ ಇದೆಯಾ?
ಆಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ.
ಮಾಡ್ತಾ ಇರಿ.
Please. ಅಲ್ಲ Wednesday may kindly have. Please.
ನೀವು ಮಾಡ್ತಾ ಇರಿ ಆಮೇಲೆ ಹೇಳಿ ಯಾವತ್ತು ಆಗಿದೆ.
158.
No problem. It will be adjourned. You settlement ಮಾಡ್ತಾ ಇರಿ ಯಾವತ್ತು ಕನ್ಕ್ಲೂಡ್ ಆಗುತ್ತೆ.
ಅಲ್ಲ 5 feet road ಗೆ ಅಷ್ಟೇ ಸ್ವಾಮಿ.
Yes.
Madam, list 3, serial number 2.
Madam, serial number 157.